into all the technicalities of the day. Until 12:30, we all stay only in this room. We will have 2 workshops. The first will follow the presentation by Professor Lach on coordination on social protection. And here we have a partner. Our partner, ZUS, the Polish National Insurer, also our honorary patron, sent 5 experts, believe it or not, as many as 5 experts, because the questions that you asked before the Congress required more consultations in a broader echelons of their staff, of their officers. After a short coffee break, we will hear 4 accounts from 4 young lawyers on novelties in their member states. Of course, still relates to posting. After the lunch break, beginning with 1:30, we split to 3 rooms, and I'm now going to number those rooms. This is going to be room A. Room B is just next to reception, and the room C is behind the back wall of C. A here, B far, and C just next door. After this session, before lunch, I'll tell you which workshop is in which room. That was also entered into our program, into the program of the Congress. Now, without further ado, no, there will be some ado. One very important bit of news after the parallel workshops. We will invite you to this room for the last session. It's the Polish National Labor Inspection. These will be the sessions of questions and answers, so I do encourage you to ask questions to our speakers. All the practical workshops are here for you to solve your practical problems. We've got our magnificent experts. They are at your disposal also when it comes to answering your questions. And now, truly without further ado, may I invite Mr. Daniel Erik Lach for his introductory presentation, 12 going 13. Thank you very much. May I now ask for to discuss today, 12 going 13, and there is a question mark after it. Because like in yesterday's paper, there'll be plenty of those today as well. A brief introduction. The problem that concerns Article 12, the institution regulated in Article 12 and 13, is being updated. It's changing in time. Here we see the data until 2019. I don't know what this structure is now, but you can quite clearly see that posting is being limited for the sake of Article 13. Why? Well, the case seems fairly obvious. We discussed it yesterday, and literature uses this data to turn our attention to a plethora of issues. Article 12 defines plentiful, very rigoristic conditions which are not there in Article 13. There is an absence of time limits in Article 13. We also see that in practice in different member states, more and more often there are stricter and stricter controls and very severe penalties for the absence of A1 certificates. So people apply for them then. And finally, and that's probably the hottest subject, as it was very nicely described, Article 13 is more susceptible to the creation of factual situations favorable from the employer's perspective. We can manipulate the reality to set up the actual thing. It's called law shopping, it's called forum shopping, and against this phenomenon, literature notices the existence of plentiful colliding norms. This is the reason why the entrepreneurs, why employers seek for solutions that are most efficient from their business perspective. Fully understandable. Now, a question comes, which is the title question in my presentation. Is there any border? Is there a boundary? We know it's got to be there. Where is the boundary between posting under Article 12 and the rule of employment in more than one member state? We have two different articles, not one, and I probably should have started from something else. I'm a lawyer, hence my perspective is a legal one, and it's related to particular acts of law, which are fairly complex, and unfortunately, this legislation doesn't help us much. Broken down into those criteria, we must know what it is. A person who performs an activity as an employed person in a member state on behalf of an employer who normally carries out its activities there and is posted. What is posting? Is working on behalf of the employer who posts you. That is very important phrase. We will repeat it. And they still continue to be subject to the legislation of the first member state, provided that there are no additional clauses exceeding 24 months and the person is not sent to replace another posted person. Now the question is, what does it mean to work on behalf of? We work for an employer when there is still a direct connection between the employer and the employee, or the entrepreneur and the employee. All right, that's obvious, but the problem starts now. How to decide whether there is this direct connection? We again return to decision number A2, which makes a reference to the following element, and that's a problem not of the gray zones that Professor Verheuren yesterday discussed, but rather linguistic issues. We, the lawyers, are very sensitive to the use of the language. Various phrases have their legal sense. Now, in the acts of law and in documents like Decision A2, they use those phrases nonchalantly. There was work on behalf, for the sake. Now we also have that the employer is reported to. Well, we can believe that it's the same, but lawyers feel certain resistance to decide that they are tantamount, that they're all the same. The employer is responsible for recruitment, for example. That's not true. If there is this direct relationship, and this would mean that it's the employer who recruits. I believe that it's the employer who doesn't do recruitment but signs the employment contract. You can have an external recruiting company. Responsibility for the employment contract. With due respect, I have no clue what it is. It's rather that we deal with this relationship continuing between the employer and employee and all the duties and rights connected to its remuneration that's least complicated. And here comes a problem, and that's a problem that you can clearly see. With all respect to all our interpreters, that's not easy, but in the decision we have something that doesn't really work grammatically. Responsibility for dismissal. Well, I understand that the posting party has the right to terminate the employment relationship, and that's how we should understand it. And finally, a phrase quoted yesterday again and again, the right to determine the nature of the work. I deal with labor law. I've done it for, well, let's not count the years. I have no clue what's the nature of the work. Looking at the Polish terminology, charakter pracy, there is no such legal entity. So it's probably about this managerial authority of the employer. So the right to command this employee is abroad, but it's the employer who says what to do, where, and how. All right, let's quickly now move to Article 13, very complex. We're not entering the details. There's no time for it. The person who normally pursues an activity as an employed person, blah, 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 is subject to the first criterion where substantial part of the activity is conducted. In the other case, there are four options. To put it shortest, it depends on how many employers there are, where they have the registered seats, and how it relates to the work performed by that person. And then we have B, items from 1 to 4. There's no problem about those. They are fairly legible. Of course, written in the legal way means complex. So these are quite difficult legislations. The key is that this person works normally, Polish word normalnie, in this way. And that's where the problem starts. Well, cool. This regulation explains how to put a boundary between 12 and 13, and then 14.7 says that it's the duration of the activity that has this role of a criterion. Well, it's questionable whether it is really so. Let's turn attention to something else. In Polish, please read it. That's the Polish phrasing. The duration of work, whether incidental, permanent, or temporary. That is how it is phrased in Polish. So permanent, ad hoc, temporary. The English version does not sound like that at all. In the English version, we have whether it is permanent or ad hoc or temporary in nature. So the situation is absolutely the other way around. Let me tell you like this. We have more and more such things. Well, decision A2 is not really well translated. That's a smaller problem. But more and more often, as lawyers using European law, we begin to notice that individual language versions are not, well, compatible with one another. And it is so that sometimes translation is an art. Finding a proper word is a problem. And then we say we'll be interpreting it. But in this case, we've gone just the other way round. Do we take into account this character of work? In English, yes. In Polish, no. Please remember that referring to European law, we don't have this authorized version. All language versions are at equal footing. We can throw a coin. How about a mini voting? I checked the German version. It's like English. The French is also like English. I didn't check all the 27 versions. If you're curious, do it, and then we can decide which version is the one that should be perhaps binding. But that's not the main problem. The problem is what we understand under certain notions. What is the duration of the activity? What's the nature of work or character of work? Is it about type, rodzaj? It's the notion used in Polish law. It's your job, it's type of your tasks, type of employment, fixed time, or perhaps without a fixed nature. Well, it's simplest to say, as I said, we have plenty of question marks here. If it is long-term activity, then it's permanent, Article 13. If it's short-term activity, that's ad hoc, incidental, that would make it Article 12. But okay, what about the third one? Because we also have here the word temporary. We can be philosophical and say everything is temporary because it's temporary only until your expected retirement. Now a question comes. If it's temporary, is it also a reference to the character of your work, to its nature, type of your contract? Should it be taken into consideration? Maybe type of labor? From the Polish perspective, it's very tempting because we have tymczasowa praca, which is temporary employment, as a legal notion, but that's a Polish law. We cannot do it. The institution we call temporary work, it's called absolutely differently in other languages. Temp work. The whole slide of question marks, ladies and gentlemen. And there are more question marks because we also have marginal work. It's fixed term, definite, so we should probably have it at 13. It's permanent. That is marginal, okay, let's not take it to our heart. But when is your work marginal? We have our practical guide, and it says that it's permanent, but its importance is negligible. We have now 3 criteria allowing assessment. We usually focus on the first 2 because they are the easiest in administrative work. Time or remuneration below 5%. But that's not all. When we speak about the practical guide, we also speak about the nature, character of the work performed. What's the relationship between marginal work to its character? Perhaps there are situations like this, but that's very difficult to explain and to employ, to use. One more problem about boundary. It's Article 14.10. It makes us consider a situation that is likely or expected to occur during the following 12 calendar months. You need to have your prophetic abilities employed here. It's not divination here. It's a certain foreseeability or forecastability is something that concerns a situation when we quite likely can decide that we would be working in a different country. Now, has it got to, does it have to, or should it result from a contract? Can we say that we are expected to foresee posting? Where is the border? 0.7, yeah, but duration of employment, permanent employment, that's Article 13, but if it's marginal, it's no longer this. So maybe there's foreseeability that it's got to be at least 12 months. And finally, another question arises. What to do when we dealing with the 2 coming together? Does 12 take precedence, or is it 13 that takes precedence? Why do I mention that? Well, because we have different opinions on that. Professor Ben wrote that 12 has primacy to 13, but in the same year, Professor Jorens wrote something that's absolutely opposite to what Professor Pennings wrote. We have regulations which are independent, exceptions to lex loci laboris, but to check whether it's posting, we first check whether we work in 2 different states, and if so, 13 takes priority. Precedence, ladies and gentlemen. Let me now propose what could be done about that. There would be fewer question marks, but in all humility, with a humble heart, I'm asking you for understanding, because this proposition really concerns labor law. We know in social law or social protection, okay, but it seems to me that we cannot abstract from the fact that what we're dealing here with is employment. What is posting? As we've already said, we've got it in Article 12 in Decision A2, and also we can reach to the Posting Directive. It's about performing work on behalf and for the employer, there's still the direct link and posting results from the employer suggesting things. It's one-sided or unilateral legal action. The employer says, in our contract, it says that you work here, but now, for various reasons, I need you elsewhere, and that's where I'm sending you to work. That's an unfavorable situation for the employee. It is impinging on his private life. Therefore, we have limitations on posting. There's a list of entities who mustn't be delegated different duties. You also get per diems and the duty to cover costs. We've got different limitations in the union law. The directive on posting is really the sum total of legislation that protects the employee's interests. In this context, I let myself read Article 12. We not only guarantee certain rights, but also social and legal. You're staying in the system you are in. You went abroad, theoretically, you could be in a different system, but so that you don't lose, so that you don't get a patchwork biography, you remain within your original system. Why? Because in the case of posting, it's not about the freedom of the flow of labor, of employees. Because posting, as defined in the preamble of A2, this serves the principle of freedom of movement of services. And that's the root of all those posting services. I start providing a service border, and I do it with my people. And that's just like we heard yesterday in the verdict. A posting employee does not participate in this foreign labor market. He doesn't take any jobs. He's gone there. Sorry for that phrase. He's there as a tool used by the entrepreneur who uses him to provide services across the border. Article 13 is absolutely chalk and cheese from that. It's working normally in 2 or more states. And let me again get to 14.7 of the bylaw. It's about the time that we work. And there's the second sentence. There's a general assessment of all the circumstances. And these include a place of work specified in the employment contract. That's Article 14.7. And that matters for us. Then 14.10, we see here the probability. If we have a work contract where it says that you work in Poland, Belgium, and Germany, or we have a sum total of such contracts, we would likely work there. Well, there may be a termination, accident, the activity may stop, may cease, but it's likely that such a sequence would occur. If we work in Poland, assessment whether we are going to be sent to work somewhere else, that's a subject that, okay, not looking at incidental cases, that's disputable. So the normal performance of work results from what's ensconced in our contract. It's a fundamental difference. That's not a unilateral decision. Employee, you say farewell to your family and you leave for a month. No, they sign a contract and it says he works here, there, and there. And that's a consensual decision of two entities signing the employment contract. Defining the place of employment is a fundamental element thereof. In consequence, that's an expression of the freedom of labor mobility. He says, yes, true, I participate in the Polish labor market, but by contracting a foreign employer, I want to operate in that market. If that happens, can we have a coincidence of those two? And what happens if those coincide? We've got now a posted worker, and then they sign a contract in the same state, in a different one, with the same employer. Is anything special happening? No, not really. Now, we are, however, within the area of Article 13. It's working in 2 or more countries. We apply Article 13, and to define where we are going to be employed, it's of fundamental significance where a substantial part of the activity is performed. So this protects us from circumvention of the posting rules. There are often such arguments also in literature, but in practice, entrepreneurs are going to, invent things, various things. Possibly, quite likely. They do it also without posting people abroad. The Polish ZUS, in the context of different coincidences of employment titles, they've been following them for 25 years. Things happen. We've got different contracts. We can say that the contract was fake. We can say that it's not a true contract, but we cannot explain laws by definition deciding that people will be circumventing them, because that is, as they call it, putting the cart before the horses. Another situation, I've got 2 employers and one working in 1 or more states, and one of them posts me. What happens then? Then we start applying Article 12 in the understanding that a question arises: which legislation is my first one, the one that was first defined on the grounds of 13, and is binding? I must be protected against a change in this system that would result from posting. Closing. Unfortunately, I'm not on time, but this is really my last slide. Closing. Articles 12 and 13 are 2 separate rules about 2 hypotheses. For those who are not lawyers, a hypothesis is defining the conditions when a given rule of law is to be used. These differ. They concern different situations. They cannot be seen as a single whole. There are separate exemptions from lex loci laboris. I say that posting results from an instruction of the employer. From the perspective of administration, it's very easy to decide. In the case of Article 13, we can see that this reflects what we see in employment contract or contracts. And inspection, labor inspection, administration, or the insurer, they check how many places there are in different contracts. If many, 13. If only 1, but the employer told me to go there, it's the Article 12. And if we have concurrence, usual, it depends what came first. If first posting, then contract, we leap into 13, and this significant part, substantial part counts. If it's the otherwise, well, we start from Article 13. Thank you very kindly for your attention.
Szanowni Państwo,
Ladies and gentlemen, that was a very fresh view on Article 12, and also quite provocative, because those of you who post their workers know very well that when you use Article 12, you use the annex to the contract in 90%, where, by the agreement of both parties, this place where the work is performed is replaced temporarily by the place abroad. This is acceptable by law, but it makes this dichotomy that Professor suggested a bit more difficult. Now let me ask Mr. Andrzej Szybkie to introduce all the speakers, and I encourage you that you ask our ZUS experts questions. Good morning, ladies and gentlemen. The ZUS, or Polish National Insurer, in a moment we will try and tell you what all this looks like in practice. And the first reflection is that we all have to apply all these rules, so we have to have some idea how to do it. And I believe that there will be several aspects to our presentation. So first and foremost, we need information on what's changing in ZUS, Polish National Insurer. Then we will speak about significant decisions of the European Court of Justice. And then we will also reply to the questions that you posed and that were collected by Marek and Marcin. Let me now introduce my team, Ms. Marta Pardyka, who's the head of the Department of International Benefits at the headquarters of Polish National Insurer. She's responsible for interpretation of instructions. Mr. Tomasz Potaczała is a lawyer who analyzes regulations and says what the legal grounds are, how we are to enforce legislation and decisions of the court, and Krzysztof Delert-Urban, who is responsible for control. So he's responsible for the execution. So he supervises the departments that enforce the law. And he also checks whether this glass ball, fortune-telling glass ball, whether it worked well or not. Okay, I'm being quite ironic, but of course it's not easy to check how individual departments will interpret the law. So let me now ask Marta to speak about what we do. Good morning, ladies and gentlemen. My name's Marta Pardyka. I will present to you the process of application, issuance, and verification of AI forms. Before I speak about the process, I will, by a word of introduction, tell you how we operate in ZUS. I will speak about our tasks. So this is how we are organized. So we have the Department of Benefits and International Insurance. And we check the procedure. So here the number of forms is a bit lower. These are A1 documents issued over 20 years by ZUS, the Polish National Insurer. So we have this growing trend with a drop in the year 2009, which was related to financial crisis. Another drop was observed during the pandemic, the COVID pandemic, but then the number of documents issued was growing because of inflow of Ukrainian citizens to Poland. And now we have the level of the number of these documents at the level of 850,000, over 850,000. Now, the main destinations for the posting of workers under Article 12 are Germany, then agencies. Here we have a comparison of number of A1 documents to unique number of persons for whom the documents were issued. So here we see a clear difference between the year 2025, where we saw an increase in the number of documents, but we've seen a drop of in the number of unique persons, which shows that either there was a change of the employer or additional countries were added to the where the work was performed. So here, one person within 1 year was issued 2 documents because there was a change either of the employer or in the way they performed their work. Now, when it comes to third country nationals, we have prepared this comparison. And here we see this difference between the number of A1 documents and the number of unique persons. And in 2025, the difference between these numbers has decreased. It's not as visible as it used to be if you take all the documents. So here we have TCN persons, and the difference is much lower. Another slide when it comes to third country nationals, a comparison between the A1 documents issued against the number of all the documents issued by ZUS under individual articles. Now I'd like to speak about the most frequent reasons why the Polish national insurer withdraws A1 documents. So we get requests from international institutions. So, for example, there's a failure to meet the criteria for conducting a significant part of the business in Poland by the posting employer. So, for example, this activity is solely administrative. There is also lack of infrastructure of this activity in Poland, or there's placing of the employee at the disposal of a foreign employer, and also unauthorized replacement. It may turn out that this work in Poland was not performed, or it was marginal. So the wage or time of work was below 5%. So then there's the necessity for A1 document to be withdrawn. And the number of A1 documents withdrawn in connection with proceedings initiated at the request of a foreign institution for which Polish legislation is not applicable is the following. Well, it's very small, because in 2023 it was 326, in 2024 951, and in 2025 we withdrew 1,154 A1 documents. Let me move on now to the process of applying for the document itself, it will be simplified for employers because the PUE platform, so the digital services platform, changed into eZUS portal in February. So now this change concerns 1,700,000 payers, so they can now use this new functionality of eZUS portal. They have been selected, and the other ones, they have this portal in its older version. So now these applications have been moved to a single catalog. In the past, they were available through a catalog of services. So now all the applications will be in one location, and all the cases, all the tasks that the employer might wish to deal with through this portal will be ordered thematically. Now, the application itself will take place in stages. So the customer will see every stage of the process, of the application process. So there will be this advancement bar. You will see the number of stages that are still ahead of you. Now, the applications have been divided into thematic blocks. So far, not all the applications that were made through the portal made it possible to take the data of the employee from the portal, but from now on, you'll be able to collect it for all the applications. Well, when you fill in the forms, you need to provide additional information such as US 54 that concerns third country nationals and US 55 that concerns citizens of EU, EFTA and UK nationals. So now, in the past, they had to be attached additionally, but now in this new portal, it will be done automatically, depending on the choice made by the customer at a given stage. And the most popular applications that concern Article 12.1, 12.2, and Article 13 will include these additional questions to facilitate the application process and selection of the appropriate application form. On the left, we see this application creator as it looked so far. So it generated, now it generates these additional tips and tells you which form to use. In the current version of PUE, this creator does not include these additional tips. And very often, when you run a business activity, people say that they will do their job in two countries, but what they mean is performing their job temporarily in the territory of a foreign country. So at this stage, mistakes are made, and if someone wishes to apply for self-posting under Article 12 actually does it under Article 13, which is wrong. So we have introduced additional tips for applicants so that they know which answer to tick off. So, and also there are explanations that this work in another country means if you work only in that other country. And if you select multiple countries, it means that you simultaneously, in a given period of time, work in multiple countries. So this is Article 13 and Article 13.2. There is also this suggestion when it comes to the application under Article 12, saying that the maximum period of posting for an employed worker or for someone who is self-employed is 24 months. Now, it is possible to apply for a longer period of time, which obviously is impossible unless the payer has an agreement already, and then they can apply for A1 document under this special agreement.
What would it now be with the payer? There are plenty of different ways of helping the payer because the payer applying for document cannot see who this concerns. After the change, there will be the PESEL ID and full name seen, as well as the stages of the case concerning this application, whether the application was already approved at ZUS, whether we still, on the client side, it's still a draft, or perhaps there is already an answer from ZUS, and this progress of the case will be visible here. And this view contains both those regular columns, name of the case, stage, date of last update, and columns that the client can add or remove themselves as they wish. They may want to see historical applications of who sent this application, who in ZUS collected it or received it, and they can adjust the view to their needs here in this screen. The following thing that changes is the visualization when it comes to the type of answer received from ZUS about A1 documents. We hear suggestion of the type of the answer, that it was an issued document or refused, or there is some kind of response that explains that you need to attach some more documents, provide some more documents. You can also apply for A1 in mZUS app. We still ahead of us, but it's very near, very, very soon. 4 of the most popular forms will be in the app. These are the ones that concern 12, 12, 1, 2, 3, and 13, 1, and 2. There will be more hints given when it comes to work in one state, when it comes to the period for which you apply. You will see those in the app and also on the eZUS portal. So both the application and the answer will be visible both in the app and via the portal. Now, filling in the additional information about the place of residence, so information for US 54 and US 55 will be there, and you will be able to do it at the stage of filling in the application. What does ZUS verify when it comes to this situation. That's a nice reference to the previous lecture. Where do we focus our attention on most? What do we verify? What do we assess through additional documents? That's running a majority of work in Poland. That's 12.1. The turnover and the value that makes a general impact on the assessment of activity, the number of staff, the number of contracts, the number of posted workers compared to the number of the ones staying in Poland. Also, those who stay in Poland, you can't count among them the administrative staff. Administrative staff should not be counted into that number. And the period of insurance of the person to be posted is to be also examined. They should be insured for over a month before posting. If this doesn't happen, this condition can be deemed fulfilled if that person for a month lived in Poland. So that condition is assessed from the US 54 information, especially for third state countries. These have to correspond to the periods of stay which are listed in this information. We have here the famous verdict of Valtopia. That's the European Court of Justice. So it has to be realistic in this information. They don't enter any periods of stay before the period of posting. If we cannot use our systemic data that they were insured with this payer or another payer, then the fact of residence will be verified based on the information provided or explained later. The following criterion, it's already been mentioned in the previous paper, that there is this direct link between the employer and employee. That's the question of the contract of being valid throughout posting. So A1 cannot be issued for a period that exceeds the term of the contract concluded in Poland. It's for the time that's entered in the application, and the employer also states that they are responsible for paying the remuneration throughout the period of posting, that they are responsible for recruitment, which is understood that the employment contract is concluded between the employer and the employee. And then the verified issue of replacement that results from the statement of the employer. It's also verified when it comes to the sites to which the employee is posted, and we can also verify it with specific foreign businesses. Now comes the question of the period of posting. It cannot exceed 24 months. If we know that it's going to be exceeded, the payer should first submit US 36 about signing an agreement, and if this agreement is granted, they can also request A1 form, but then it's based on US 34, which concerns this situation after a special agreement has been concluded, exceptional agreement. That's where we see the key data. That's the data that's assessed. Number of people working in Poland, number of posted workers, questions of concluding contracts, and then the turnover. This data should correspond, they should be correlated. This data should cover the period of the past 12 months. If this work hasn't been conducted for so long by the employer, it should be for the period when that employer really worked like that. A1 should be generally applied at proper notice, and the data should be validated for the day of its submission. ZUS can verify through control the data, obtaining also information from the tax office when it comes to turnover. So at all the stages, in a way, we can verify the information shared. When it comes to Article 12.2, that's posting, we mostly assess the contract signed with the foreign partner. It should cover the whole time that is now applied for. Also, the very fact of issuing the documents confirming that they run activity in the required part at least 2 months before taking that work abroad. These can be invoices, these can be contracts that have been concluded here in this period. What is also verified, the type of the actual activity, what as yet, well, in what field you've worked so far, and for what sector you have signed that contract. Whether this is the same sector, whether this is perhaps an entirely different issue. We're looking at the PKD codes, and if this is submitted for another period, you verify whether this activity continued after returning to Poland. So this activity has to be restarted because the fact of its actual continuation before the following posting is also verified. Speaking of US4, simultaneous or alternating work in different countries, verification is done through the contractual clauses. And like a trade representative who works in multiple countries, for example, the contract points to the fact that they really work in different countries. It's also verified. They also verify the proportion between employment and remuneration, the marginal work that takes less than 5% of the duration of work or is also taken into account here. Referring to those values are those fields, and for every state where this work is to be concluded, these fields are obligatory unless the payer notifies in the submission that it's a driver in international transport. In that case, we do not require those values concerning the duration of time and remuneration, because if there is one employer in Poland, that person not even performing much of work in Poland will be liable to Polish legislation due to the seat of the employer. The data should come from the previous 12 months. If you can only plan for 6 months, then we can also issue this document originally for just 6 months to be sure that in this time you will work alternatingly or in parallel. And for the situation covered by Article 13.2, we also verify the alternating or simultaneous work in different countries, and we assess a timetable of work, foreseeable, or contracts that would be carried out in such a way. It's also assessed whether this work is carried out in Poland, at least 25% of number of services provided, time of employment or work. This also, in this way, excludes marginal work. That's how the application is defined. For every state, the client should name those values and also presents the center of interest. That's something that may be important when they work less than 25% of time in a specific state. Then we can also pay heed to the intention of the employer, where they think they would be concentrating their services in the 12 months. Well, now the question of differences and how to approach the time and nature of the work when we apply from Articles 12 and 13. So this is also the question of posting by the employer for temporary work. So what is assessed? Well, the previous operation of the employer and retaining this direct link between the two during the posting. In case of application from Article 13, this work in the territory of multiple countries must be of permanent nature in the following 12 months, or if the period is shorter, that shorter period should correspond to the contracts concluded, and assessed here is duration of work and remuneration. And the criterion of turnover may not be filled. Well, a motoring company only employed people, wanted to send them for training. If ZUS doesn't know it, using this criteria, they will turn the turnover, and these were probably only now signed, and you suddenly needed to send people for a training in, I don't know, quality, for example. So we must be aware to adjudicate properly this information, any information must be there. If we already know that there is the criterion of turnover, or the criterion of the number of people, has not been fulfilled, we may provide additional information. How about third country citizens? We assess here all the conditions from Article 1 of 1231. We check whether that person has the right to stay legally in a member state, whether they have the right to provide labor in Poland, and remaining in this transborder situation. By that, we understand that there is the posting state and the receiving state, or there is permanent provision of labor in multiple countries. Only when that receives positive assessment, we confirm that there is this legality of living. We look at Articles 11, 12, and 13. ZUS does not verify the document in the receiving state because that is not something that would result from Article 1. And then also the regulations of the receiving state define that. For that reason, this is something that we do not verify. When it comes to the possibility of confirming the A1 document in case of remote work, that is possible when we use the conditions resulting from posting, if the classical criteria have been met, and if that has been agreed formally or not with the employer, and that situation then can only concern one state. In this case, such a document can be confirmed from Article 12. However, if this remote work is a part of a general system, which includes provision of labor stationary in Poland and remotely when abroad, then there is this possibility of confirming the document from Article 13 if none of these works is of marginal nature and is part of some regular scheme. We may also have a special option here, principles of using the legislation of the state where you stay if the duration of work there oscillates between 25 and 49%. You can have a change, and then you can use the law of the seat of the employer. That's based on the international labor law. And in this way, if that person only works in the two states, the state where they live and the state where the company has a seat, they can get such a document based on this derogation and an appropriate form, US 36, and you need to enter that this is a derogation on remote work. These are the criteria of exclusion, of exemption from the rules, of applying the rules that result from the above. If you are neither posted nor working in multiple states nor working remotely, you can conduct an extraordinary agreement based on Article 16, and that's preceded by our Kielce branch, so there's that option on the table as well. And then issuing the A1 document, once it's been issued, it's done electronically because they are all by principle issued electronically. And you have also a validator service which lets you check whether the A1 was issued or not, and if it was issued, whether it's valid or not. ZUS, by confirming A1, informs about it through SED, electronic document, and the SC system. So this information goes immediately to the place where you provide labor. When do we have to notify ZUS about any changes taking place in the context of the document issued? Well, the first and the foremost issue is notifying that labor abroad has never taken any place or was terminated earlier. Then a new document would be issued for the period of the actual provision of labor. You also do it when the break in provision of labor exceeds 2 months, when also the place of work changes. You start working for another foreign partner, for example. It's also about the change of identification data of the address of residence or domicile, and Article 13 and dissolution of contract with that employee. As I've mentioned, the document is verified mostly to the requests of foreign bodies, and ZUS only verifies and in the wake of its control or results from some other information, for example, presented to the current application as attachment, for example, and that can verify your previous A1 document because perhaps some circumstances have changed, or if the employer made some statement. That statement may, for example, differ or diverge from our controls or our documents. Now, what are we going to do in the coming months? It's a review of procedures and then fine-tuning those. That's a general task for the whole of ZUS, not only our area, but all the areas of the Polish National Insurer. We will also work on automation of various ways of documents. We'll try to automate specific applications. And we also in for work when it comes to putting A1 documents into digital portfolios, and that's part of the ADOS 2. Thank you very much. Speaking about update of our information on how ZUS proceeds, now it's a request to Tomek. Marta, thank you very much. And thank you very much for that. We are a bit delayed.
Jeśli Państwo
If I may. Indeed, we have very little time before the break. I suggest that we reverse the order. So maybe first we allow questions from the room, and then we can discuss the case law, provided the council agrees. I'm sure you've got questions to ZUS, to the Polish Social Insurance Institution. I'm sure you do. So Krzysztof has some answers to the questions that have already been collected. So maybe we could do it this way. I believe that many questions can be answered ahead of time in this way. Good morning, ladies and gentlemen. Ladies and gentlemen, it's a pleasure and an honor for me to face the questions you have, especially when it comes to establishing the applicable legal system. You have asked a number of questions. They had been collected before the Congress even began. I will take this opportunity to answer these. I will first read them out and then I'll give answers to them. Without further ado, question number first. So how does ZUS verify and identify the significant part of work under Article 13 of the regulation when an employee is sent on various missions to various countries? And my employees go on 2-3 month contracts to Germany, then to France, and then they return to Poland. So, how does Zeus test this criterion? Do they consider the number of hours worked in this 12-month period? Do they look also at the remuneration attributed to work in a given country, or maybe then a number of tasks or the revenue generated in a given country? So which of these criteria are binding and which are auxiliary for the Polish social insurance institution? So you've got the establishment, the branches thereof. Look at the significant part of work where it's done, and they look at Article 14/8 of the enforcement regulation when it comes to employment work. It is suggested that we consider time and remuneration. When it comes to self-employment, there are a few more factors. So these criteria are looked at, and if the ratio falls below 25%, it's indicative that a significant part of work is not performed in any given member state. So, whether it's a shorter period or longer period, this does not impact the methodology that has been adopted by Zeus here. It is by no means necessary to actually consider those 12 months, because you've got the provision which says that you consider a hypothetical situation that is probable in the period of the following 12 months. Some of our clients believe the following. They think that the A1 certificate needs to be issued for 12 months, but it is not the case. When it comes to 13, basically, the certificate can be issued for a time for up to 12 months, but it can be shorter. So 12 months is an interesting deadline. It allows us to look at a potential situation. If this period were longer, you could have problems in the future, because hypothetically, you might see that timetables do not find any reflection in reality. So the lawmaker was quite right in thinking the following. The lawmaker, the legislator, never allowed to apply for A1 certificates well ahead of time, so that they would be very long. So yes, it is true that you can have A1 for a shorter period. However, it needs to be reflected in the timetables, so the work needs to be done at the same time or interchangeably, because sometimes you've got the other side of the spectrum. People apply for very short periods, to the tune of a few weeks, shorter than a month. And then you have a problem, because it is not sure what you're dealing with. Are we looking at work performed in 2 member states, or maybe it's just an incident, whether it's incidental? Now, this activity can be performed in short periods. So those people leave for a few days, then they return, they leave again to the same member state. This is when you might consider applying Article 13, because it's clear that there is some changeability, so the member states do change, right? Another thing is to be considered. Maybe, feasibly, you could apply Article 12 here, because you have short breaks in posting are not a direct impediment to withdrawing, or are not a direct reason to withdraw the certificate. So if conditions are met to issue A1, then you could apply under Article 12. I'll get even more technical. There are some situations where you have an employee, they perform work under Article 13, they are employed by one employer. This is when we look only at the working time criterion. It seems quite obvious, quite straightforward. You have one employer, right? Usually that employer is in Poland. And in such a situation, you don't have to split remuneration between member states because working time criterion is going to be sufficient, right? Because a given person receives remuneration from one entity only. However, you might have a situation where a person is employed by two employers and they have seats in Poland. That is when we are going to consider working time. However, when it's a number of employers, we will consider both working time and remuneration. So these factors. Another important criterion is the seat of employer, because the seat of the employer, the place of business, is going to be relevant when you want to find the applicable legal system, right? Next question. So you've got this changing work. Does this require that the timetable for the next 12 months is fixed, or is it enough to present a flexible, predictable mode of cooperation with your foreign clients? So you need to present your work schedule of your work in a number of states. In my industry, which is project-based, it's difficult to plan everything in advance, especially the project. So how flexible can it be? What is this going to accept? Do we need particular tangible contracts signed with our partners? And is the ex post audit going to be a rule here? Speaking from practice, well, our experience tells us that the more detailed the timetable is, the higher the likelihood that the legislation, applicable legislation, will be fixed and it is not going to be revised after the fact, but there are no guarantees. So you've got a type of work, it might make it impossible to draft a detailed timetable. The employer may not be able to describe in advance how this work is going to go and which member states. Then you need to provide a certain pattern of work that is the most likely according to the employer. We are not going to get any better document, right? This is the best we can get, so we are going to follow whatever we've received from a given employer. So when you apply for another A1 certificate, then you might see an audit of the timetables. Or rather, it's a rule rather than an exception. And branches will always ask that you present the previous timetables and explain them. It is possible that such an applicable legal system may be changed ex post. What's this practice when you've got an employee that's been granted A1 as a person working in multiple states? In reality, spends more time in one of the member states, it is not Poland, more than in others, but it is still below 25%. So we assumed that the work in Germany was 20%, or rather that the assessment was that the work in Germany would be 20%, but in practice was 24%. Would that be a good reason to question the A1 certificate? What kind of deviation would be acceptable by ZUS? And what about notifying ZUS of a change in these proportions of ratios? Let me put it this way. When it comes to small deviations from the predicted timetable, in practice, they are not going to change the applicable legal system as defined by ZUS. But, you might see a change in the applicable regulation. So we're talking about 1213, right? So you've got a person that does a significant part of their activity there. And if the 13.1a condition is not met, the change might occur. Foreign institutions see that because we send them digital forms, we call them SED, but it is not something that you can see in the A1 certificate, because there you've got Article 13, Section 1. So if that happens, there is no need to change A1, but we need to make a correction in the SEC digital document so that the foreign institution is informed and well aware what was used to define the applicable legal system. There is no defined margin of error here. ZUS branches will inspect these cases separately and individually. So an individual analysis is performed. And if the conclusion is to change the applicable legal system, it happens. It doesn't happen all too often, but it does. When the conclusion is that the change is necessary, the certificate is going to be withdrawn. However, the change might be relevant just to a part of the period. Then you can see a situation when the certificate is shortened. And after the period has elapsed, the Polish legal system is not going to be applicable. How does ZUS verify the actual character of work when posting happens to countries when you've got the Limosa system? Is registration in such a system is by default assumed to be a proof of working in any given country. So the very registration in the system is not a criterion that we take into account. However, it is going to happen when we need to explain something, because quite often what we see is this. You've got employers who delegate or rather post workers, and they sometimes fail to make changes to the Limosa system information. Sometimes posting never happened, or maybe the period was different from what was originally expected, but it had already been input into the Limosa system. So you see quite common cases where the Belgian institution reaches out to us, to our colleague that is responsible for investigation, and this institution asks, is it really that this person should be posted because they've got a valid A1 certificate and they should be working in Belgium? And if there is such a situation, it requires explanation, right? And usually we learn that, yes, you had this information in the Limosa system, but the person failed to leave, they were sick for a few weeks, and then an employer basically reapplied, and there were 2 overlapping periods, and it needs to be cleared, right? So when it comes to the Belgian and other databases, you have to be careful there, because if you fail to make everything right, we have to basically launch an investigation to see what the facts are. Also, ZUS can reach out by themselves and reach out to the budget institution under the regular cooperation. What are the particular expectations on the part of ZUS when it comes to documenting the activity in Poland in the context of further A1 periods? I mean, posting and parallel work in a number of countries. When you've got another A1 certificate for the same employee, ZUS is ZUS going to insist on documenting activity in the previous periods? Right. So when it comes to requirements on which information is necessary, is going to depend on the kind of application you're making. Are you talking about posting or multiple employment? The regulations themselves expect different things depending on the case, and the periods are limited. All the criteria are basically different. When it comes to posting, the link between the employer and the employee is important. But there is also an important link between the employer that does the posting and Poland. I've got a suggestion here. Maybe, or let me rephrase that, questions and answers will be made available to you. But question number 11, I believe that Tomek could help you here. I think that it has happened a number of times. We're talking about students under 26. There is a special contract under which they are employed. We're talking about Austria here. Could you clarify that? Yes, it has popped up a number of times in our correspondence between employment agencies and the Polish Social Insurance Institution.
I have very good piece of information to you. Because of the change of the interpretation of the Supreme Court and the decision of the Supreme Court of January 2021, we came to conclusion that the decision of ZUS that we've had so far should be changed. We now know that it will be possible to issue A1 forms for students and those who have graduated from secondary level education who are under 26. They should be notified to the ZUS system, and the Supreme Court decided that the condition of being subject to legislation before posting can be drawn from the very fact that such a student has health insurance because he's a member of a family and has such an insurance, or a rector of a university might do it. And even though such a student could not would not have this insurance, then because he lives in the territory of Poland, this condition is fulfilled. So currently we are developing recommendations and guidelines for our departments, and I believe that soon it will be possible to apply for the issuance of A1 form for this category of employees. Thank you for this applause. Well, it only confirms that our way of thinking is good. Tomasz, could you just comment on one sentence? It's against GKV Spitzenverband concerns this substantial part of work and concerns the territorial aspect. So the consequence of this ruling is that you have to take into consideration not only duration and wage, not only in Switzerland and EOG countries, the European Economic Area, but also the duration of work and wage that is seen in third countries. Thank you very much. We finish right now. My apologies, ladies and gentlemen. We have health and safety rules. We have interpreters who really deserve their break. So now we will have a break. And because you know what Zeus experts look like, you will definitely find them during the coffee break. So yes, let me now invite you for a 30-minute break.
Bardzo przepraszam, to, ale znaczy organizacyjnie po prostu nie mamy tutaj czas pracy. Nie mamy tu. Wiecie, tak. Więc to jest. Natomiast ja mam jeszcze wyjątek. Znaczy ja wiem, że to nie jest państwo, to jest Polakia, ale zapytam sobie już Igor, bo to jest po prostu niedorzeczne. One są najgorsze jest gdy się rozległy brandami, się do tych brandów zresztą że człowiek jedzie za granicę bez bezpieczeństwa, nas to oddaje w ręce. Jeśli mogę, to już teraz oczywiście też zasługuję. Bardzo dziękuję.
Raz, 3, 4. Czy lampy są równie fajne jak wczoraj? Maćku, weź iść po prostu, żeby przynieść.
A ile jest? 4?
4.
Serio? Gadałeś z mikrofon wczoraj?
Tak, tylko on nie wiedział, że złączony. Leczko. Weź Maćku iść po te, żeby przynieśli jedną po prostu szklankę z podkładką.
Dobra. A mam zwracać jeszcze, czy
Tak,
nie?
tak, to da się przesunąć. No mówię, te lampy da się przesunąć.
Co to odkrył?
No przesuwajmy tak, żeby to było równe.
No to jest dałbym bardziej było.
No daj w lewo.
Nie, najpierw stoliki.
Halo?
Ale ono nie może być tak odwrócone.
Bo jednak 5 osób jest.
Jarek to słyszał. Ja się to sobie załatwię.
Proszę świecić tam.
Ladies and gentlemen, thank you very much for coming to this session.
Szanowni
Young lawyers, as we call it. No, I mean, look at them. And we will have a brief, very dynamic overview of what is happening in Italy, Poland, and the Netherlands when it comes to posting of workers. And let me introduce Daria Matecka from Giulio Cesare, Davide Vieni from Vieni, from Udine actually, but yeah, the company is called Vieni. David Wernsing, from David Wernsing, no? And my dear colleague from Department of Labor Law of Gdańsk University, with whom I share the room at the University of Gdańsk. So we start with Italy, and Daria, take us to the journey,
To Italy. Good morning. So, good morning, everyone. It's a huge pleasure for me to be here. One line about me, so you know my perspective. I advise only foreign companies operating in Italy, mostly contractors, service providers, sometimes investors setting up operations in Italy. So today I will not bring you much theory. I will refer you on what happens on real sites, on the ground, when usually the time is short and the money is on the line. So in the cross-border service provision in Italy, you have two gates. You foreign operator, of course. The first gate is the classing one, is the remuneration and working conditions. The headline in Italy, you know, everybody probably knows here that your headline in Italy is that we have no statutory minimum wage. We have hundreds of collective labor agreements, and that often overlap. And Davide will go further on this point. But there is the reality from my practice. Almost 100% of my clients come to me for gate 2, which is safety compliance. It's usually one of two stories. Daria, we can't start. The client will not let us in. Daria, we received a checklist, 20 pages of documents, roles, trainings. We don't even know half of them because those categories are very Italian. And here is the point. This hits small, occasional projects the hardest. If you work in Italy often, you build a routine. You have templates, train people, trusted consultants, you amortize the system. But if you come for one single 2-week project, safety behaves like a fixed entry fee. Same checklist, same structure, even if the project is small. Legally, Italy can do this. Under Article 3 of Posting Directive, health and safety is part of the whole state hardcore. So Italy applies its occupational safety and healthy rules to posted workers on Italian territory. And at European level, till today, we just have OSH principles, the minimum OSH principles. So we don't have any European operating manual for roles, training formats, and proof. Italy, it's not just Italy being for safety, with regards to safety, it's not Italy just being difficult, it's also Europe being fragmented. In Italy, for example, operating a forklift is usually an OSH training, so the worker gets the course, the certificate, the employer's authorization. For example, in Poland, the same activity is often tied to formal qualification, certification. Many of you knows the Urząd Dozoru Technicznego, which is like a kind of Office of Technical Inspection. So an Italian forklift operated posted to Poland is not automatically deployable. he will need a recognized equivalence route directly or the acquisition of the Polish qualification. So there is no European-wide forklift badge. Operator may need to adjust credentials depending on the country, like switching SIM cards. So yes, safety is the bouncer at the door in Italy. You can have the best team, the best price, but if you are not readable in the Italian safety system, your access gets blocked before the first screw dryer turns. So why Italy is so heavy and feels so heavy? The backbone is Legislative Decree 81/2008. It's a full occupational safety code, 306 articles plus large technical annexes. But of course, the key is not the number, the key is the idea. In Italy, safety is organization and proof. It's not enough to say we are safe. You must be able to show in an Italian format that you have a risk assessment of your company, clear internal roles on site, coherent trainings, and a site-specific documentation pack. Now, the biggest multiplier we have in Italy for safety is cantiere, is temporary or mobile construction site. And this definition is much broader than many foreign operators expect. It can cover classic building works, but also assembly, installation, dismantling, maintenance, refurbishment works, and many others. So a foreign company usually say, we don't do construction. And the Italian client says, maybe not, but you are still in a cantiere, you are still on the construction site. And then everything changes. So you will be asked to acquire for your company a formal role architecture with prevention protection function, on-site supervisor, first aid and fire protection roles, often also the RLS, which is Italy's formal worker safety representative. Other countries have equivalent functions, sure, but the friction for the foreign operator is that Italy wants them formalized and proven in an Italian readable format. So, and now let me show you some numbers, because businesses, I think, need numbers. So on this slide, you see a small example of typical classic safety pack costs. For a foreign company posting about 10 workers for a simple installation in a cantiere, in the construction site, with no high-risk tasks like no confined spaces, no work at high, no hot works. The first-time setup cost for compliance often sit around 11,000 euros. So we are talking about huge money. I would like also emphasize that beyond that sum, you also pay with time, your time and workers' time, plus logistics for in-person trainings and other extras, of course. The only good news I can offer to you today is that this cost and these formalities will be reusable. Your second, your third, your fourth project in Italy will be cheaper. Till today, my clients and I have been lucky. I haven't had many inspections on site, but when inspections happened, they were not about classic posting paperwork. They were not show me the A1, posting declaration, payslip, contracts, attendance list. They were show me safety training, show me medical work suitability worker certificates, show me the personal protective equipment delivery records, show me your site safety documents. This is a trend many companies see in Italy, and inspectors quickly focus on the safety files because it's the fastest way to check real compliance, and the penalties under Decree 81/2008 are serious. And here comes the most important practical points for cross-border businesses. In Italy, your first inspector is often not the state, it's the client. Why? Because the client has serious exposure. Coordination duties, work stoppage risk, sanctions, reputational damage, and in serious cases also criminal exposure, so the client behaves rationally. Compliance becomes a contractual entry condition. Documentation is required before access. Proof must be Italian readable. That's why no documents, no access is not an attitude in Italy. It's a risk management. The Italian client doesn't love documents. The client loves sleeping at night in Italy. And the most painful operational issue is equivalence. In Italy, one safety coordinator engaged by your Italian clients accepts foreign trainings and will consider them equivalent. Another will reject them at all. And the same company will get opposite interpretations onto projects. Now, in Italy, the new chapter that matters for foreign operators in construction sites are patent accredited, the so-called points-based license. This is the late 2024 development, and the Italian legislator explicitly extends it to foreign operators, European and non-European, as long as they operate in the relevant site context in Italy. The system works like this. Companies start with 30 points. Credits, the points can be reduced for serious violations or accidents, and in some cases, the points can be even increased through virtuous behavior. If the balance drops below 15 credits, the company cannot operate on Italian sites within the scope. Operational, this is a pre-qualification gate in Italy. It is obtained and managed electronically for foreign operators. There are two frictions: digital onboarding into Italian systems and substantive declaration. So the foreign operator must be able to state that key Italian safety requirements are already in place, including the prevention, protection function, and so on. And in this case, on this chapter, the sanctions matter. Operating without the points-based license in Italy can trigger 6,000 euros of sanction, or even 10% of contractual works value when the works exceed 60,000 euros. 10% can wipe out the margin on the project. The second novelty we have in Italy is the electronic site badge. This new chapter will introduce real-time traceability of workers on site, attendance, working time, contractual regularity. It's still, fortunately, not fully operational because implementing rules are still pending in Italy, but the direction is clear. More digital control of who is on site and under which company and status. I would like to conclude that in Italy, health and safety is not an add-on, it's the entry fee. Yesterday we talked about enforcement, when it protects the market and when it turns into a barrier. Italy is a perfect case because our historical response to workplace accidents has been okay prevention, but also evidence, responsibility, and control. In plain terms, more rules, more paperwork, and more people wearing a hat with a signature underneath. And the market outcome is simple. Italy is not a closed market, it's a selective one. Those who arrive already structured or who can structure themselves get to work. Those who arrive light often stop at the gate. Thank you.
Thank you very much. That's a yes, yes, Anna, go. That's a very interesting perspective because we never actually touched health and safety requirements during the Congress because it's always the wages, the structure of the wages, the working time, what brings problems, not in Italy. In Italy, it's health and safety regulations, and that's unusual for the European Union, I would say. Davide.
But it is actually really worrying for Italians because we have a number of accidents, and every time there is an accident, actually there is a very strong response, I would say, from the public demanding more safety. So things are getting seriouser and more serious and more serious each year passing, and it's kind of good, but it's not easy. You have to come prepared, as Daria said. But Daria, one of the last things that Daria said was talking about the point-based license to access the construction sites. And it comes frequently that this kind of prerequisite, which is a health and safety one, is confused with another kind of application that you have to make, that is the cassa edile. Cassa edile is what makes really Italy part of the old Europe, because it is an institution that it shares with France, Germany, and Austria. The most known probably by you is the Soccabau. Italy, Cassa edile is basically the Soccabau for the Bel Paese. And it is mandatory for everybody working in the construction sector to apply for it, even if you are a foreign company. So this means that if you are going to come to Italy and do construction work in what Daria defined as cantiere, you have to apply as a company, and you have to make your workers apply to this Cassa edile, to the local Cassa edile. Okay, so it's a provincial level entity that is federated into a national union. And basically you have to fill the paperwork. The nice thing is that in all the websites of each Cassa edile, you can find the international section in which you can see the disastrous amount of paperwork that you have to fill out and to send them. And you have to be absolutely enrolled in this entity because it is mandatory by law, it is required to you. And this is very relevant because they collect money from you. So it's not just like a passage, I am here, I am applied for Cassa edile. No, the main scope of Cassa edile, exactly like Soccabau and exactly like the Caisse du Bâtiment in France. Je n'ai pas parlé français as well.
Moi aussi, no.
Yeah, je parlais Italien and a bit of Spanish after a bit of wine, and that's it.
Sorry to the translators for that.
Sorry. Go ahead. Anyway, their main purpose is actually to collect money every month from the employer of the quota that you accrued as Christmas pay and holiday pay, and keep it for the worker. And then they pay it to the workers each 6 months. And this is the reason why it's very important actually to make the application, because if you apply and your employees don't apply, they don't get the money. So it needs to be a circular process. And of course, such useful service that you can imagine it's absolutely paramount for providing services in Italy does not come for free. So one thing that you have to factor in your plans when you come to Italy to do construction work is that they have operating costs. The operating costs range from 8 to more 10% actually of the wages that you pay to your workers that you have to pay and you don't get back. So they are a cost for you. It's just for the operation of the Cassa Edile. And this is important, they have a higher fee for temporary workers. So if you hire out your workers as a temporary work agency and they come to Italy, you have to enroll them in the Cassa Edile and you will pay a higher fee, it's 12%. The nice thing is that each Cassa Edile publishes their fees, so you can factor them by just going to the website. One last thing that is important to know about this Cassa Edile is that its scope of application compared to other European countries is narrower. It is very much focused on the companies that are mandated to apply the construction sector collective bargaining agreement or that perform construction activity. This means, for example, that a company that does electrical wiring exclusively or plumbing, it is very likely excluded from the Cassa Edile and all this burdensome paperwork, even though it works on construction sites. It does have to have the patente accrediti, the license Daria was talking about, but it does not have at least the Cassa Edile. This is because, as my friend Anna said to me a few days ago, in Italy the focus is not really about where you work or what is your output, but is more about the essence of your activity. So if your activity is not building, but it is plumbing, then it's very likely that you are not considered to be in a building sector. And the same goes for for example, those that make windows, you know. Another thing that I wanted to tell, and then I will, pass the baton to David or to Marek, depends on who you want. Marek, maybe you want to be the master of ceremonies, so.
After David, it's David.
Okay. Yes, strictly alphabetical. It's the fact that Italy keeps pushing, as it does since a few years, on the collective national agreements, trying to bring order in this mess. Daria said that we have hundreds of collective bargaining agreements. We are now around 800 or 900. And but not everybody, every collective bargaining agreement is widely used. And most of all, as I told last year about the pirate contracts, not every contract has been signed by established trade unions. And even though there is not an official recognition system, the state is trying to push companies more and more to apply the national, let's say the well-established, the traditionally well-recognized contracts. And not having a system of recognition, that cannot be always easy to find. For example, let's say you are an ICT company that it comes to Italy, and you look for your comparable collective bargaining agreement. Among those that have been published, there is one that is for ICT companies. So you would say, well, ICT companies need to have ICT collective bargaining agreements. But you would be wrong, because this collective bargaining agreement actually has been signed by very small and not very known collective trading unions. And actually, ICT companies in Italy tend to apply much wider contracts that are commerce and services, which is the one that you use in shops or in service firms, and or metalwork industry. That is the same that is used in plumbing, by the way. It's a very broad scope of application for that contract, but you have to, know those kind of nuances. And there is also another small issue, that is that they have many contracts have very similar names, and this can create a lot of chaos when you are looking for information. And the good thing is in this is that the state is trying, even though on a voluntary scheme, to bring a little bit of order on that. So the authorities are now assigning to those contracts, to the collective bargaining agreements that are deposited to state authorities, they assigned a code, a single code. So and these codes are more and more used in practice because they allow you to be sure that the contract you are looking for is that one. And so it's a welcoming news that we hope will, keep developing also in other forms. And for example, metalwork industry is also thinking even to define its scope of application with NACE classification, which should make it even easier to understand what you have to measure up against.
That's all very interesting. It looks like the German holiday fund is more inclusive because it's contagious. So it includes non-construction companies if they work in the construction site to a certain extent. In Italy, it's vice versa. And the big takeaway is that you should look for the numbers, not for the names, for the codes for collective agreements in Italy, or soon to be the reality. Thank you very much. David.
Thank you. Yeah, I didn't really know in detail what you're going to talk about, but I have a small bridge to my subject, because to the Netherlands, because we also have a lot of CLAs, which can be a challenge to find which one is applicable to you. And we also have the reflex that if something happens, we make new rules. And that I will touch on later. But first, well, thank you, Marek, and thank you everybody from LME that I can speak here. It's very much appreciated. And when I come here, I always reflecting on the differences between Poland and the Netherlands. So after last year's Congress, I think 2 months later, I was asked to speak at a conference at a university in the Netherlands about the same topic. So it's 2 congresses, 1 topic, 2 countries, but also 2 sentiments. So whereas this one is about barriers down, Europe forward, well, the Dutch one was not about barriers down. I will leave that up to you, yes. It was more about how to tackle bogus posting, illegitimate posting, stuff like that, circumventing stricter Dutch immigration rules. That was the sentiment. And this Congress was well attended by policymakers, by the Netherlands Labour Authority, and you see that feeds into enforcement, both by the Netherlands Labour authorities as by private parties such as pension funds. It feeds through in politics and in advisory bodies. And I think that's something that we should be aware of, that posting can be, especially of third country nationals, it can be viewed as from two very different perspectives. One of the ways how it feeds through in enforcement is that you see more and more inventive, so to say, arguments from the Netherlands Labour Authority from time to time when it comes to posting third country nationals. For example, I have a client who now faces a fine because the inspector counted the days in the member state, the sending member state, and the days in the receiving member state. And I think the difference was 150 days in the receiving member state in the Netherlands and 130 in the sending member state. And then they said, well, this leaves for a change in the country of, where you usually work. So full Dutch laws apply on you. You're no longer a posted employee. You're usually working in the receiving member state. Well, luckily, because of such claims, I have a job, and that helps me. But it illustrates what's going on. But I didn't come all the way to Poland to provide you with some anecdotes. Although I can do that, I wanted to give you a bit of insight about what's going on, and I have the luxury that I am giving a workshop later where I can get into the practicality, so it allows me to be a bit more conceptual here. what I want to talk with you about is an exploration that was instigated on behalf of the Minister of Social Affairs and Employment. And to get a little bit into Dutch politics, it wasn't the current minister because we have a new government since 3 weeks. It wasn't the one before that because one of the parties quit from the government. It was the one before that, but it's very recent because it's from July 2025. We have a lot going on. There were a number of ideas to tackle illegitimate posting of third country nationals. And those range from providing more information to the employees, which is, I think, always a good thing from the government side, about what their rights are and what they are entitled to, but it also range to preventing posting below 125% of the Dutch minimum wage, or preventing posting by temporary work agencies, or preventing posting from third country nationals by temporary work agencies. Luckily, there's enough self-awareness to know that certain of those ideas require a change in EU law, and that can take quite some time. But there are also announcements that they made in July of changes in national laws. So the two that I want to talk to you about, the two action points from the letter of the minister, is first that he will push for a change at the EU level for more clarity about certain open norms. Gray areas is what Professor Verschuren called them yesterday. He called them barriers as well, and I believe that. And then Marco Rocca took the stage and he said, well, maybe the gray areas are not so much barriers. Maybe it's also good if you do not have black and white, because it can also be not in your favor. So at the moment, I don't know what I think, but that's the good thing about congresses like this. The change in national legislation that he proposed and to further delve into is a 3-month minimum employment in the sending employer in the sending member state. And if that's not there, then that the third country national involved, because it's only involving third country nationals, is then illegally employed in the Netherlands, which is, I think, is a interesting interpretation and could be challenged. I mean, after all, we have the Commission versus Germany ruling, where 6 months prior employment based on indefinite contract was deemed disproportionate. But yeah, now they say we don't do 6 months, we do 3 months. It's less, and we do no prior test. We only enforce after it's already happened. Well, you tell me. I don't know. It's a lot going on, and in the coming years. In this letter, it was we were informed that mid-2026 we would get an update. Well, as I told you, we have had 2 new ministers in the meantime, but it's still there. I don't know if we will meet the deadline of mid-2026. But I think we can expect some changes or some thoughts, balloons left out by the minister to see how he can challenge this, how he can make it stricter. And what's the justification for this? There are 2 justifications that he gives, because obviously this is a barrier. He said there's more legal certainty for the employees because there's less of a gray area. So the employee knows better if he or she is illegally employed, yes or no. And it prevents circumventing the stricter Dutch immigration system, which I think is actually the justification that's really there. Because if we look at the legal certainty for the employee, we have a bit of a problem in the Netherlands, and that's the final topic that I want to touch. I support protecting posted employees, but I don't think that this will help them in the current way enforcement is going. Because what's happening in the Netherlands is that the Netherlands labor authorities are enforcing the rules together with the foreigners police. They cooperate proactively, so they do joint inspections, but also if a worker comes to the Netherlands Labor Authority and say, "Hey, I have to work too many hours. I'm underpaid," they will also check, "Are you maybe also illegal employed?" And you see underpayment, too much working hours, you see often that it goes hand in hand with illegal employment, because otherwise other rules are also not always followed. The Netherlands Labour Authority then flags this to the foreigners police, and the worker can be deported to the country of origin or the sending member state. Depends a little bit on the documents provided. So there's no incentive of the worker to really actually go to the Netherlands Labour Authority to report those things. And therefore, I think this illustrates the firewall that should be present between the Netherlands Labour Authority and the foreigners police by enforcing these different rules. And it's currently just not there. There were questions asked about this because it was in the news in December to the minister, but they said, no, we have a firewall because the foreigners police is enforcing the foreigners law and the Netherlands Labour Authority is enforcing the Foreigners Employment Act. But they act together. So what's the firewall? So to close back and to come back on the barriers down, I think there are a couple of takeaways for you, for Poland, for the ELMI. I think there's a different sentiment here than that there is in the Netherlands. It always makes me hopeful, pro-European, but there's a gap to bridge, if you're very honest, between the sending member states and the receiving ones. And to the Netherlands, I would like to tell, if you put barriers up, make sure that the justification can actually be enforced. If legal certainty is the goal, let employees effectuate the clearer rules, or do not put up the barriers after all.
Thank you very much. Now we should, yes, go ahead. Thank you. I think we should make a quick a public poll of your opinion. Who thinks that 3 months prior employment in the sending member state of a third country national as a requirement before being posted to the Netherlands breaks the treaty? Raise your hand and push the button. Oh, come on. Yeah, thank you very much. Yeah. Thank you very much. Okay, we lost this case.
Yeah, absolutely. Yeah.
I mean, with audience in Poland, we lost this case, which means that the Netherlands will win. If this was democracy, luckily there are judges in the court, and they will declare it in breach of Article 56. Michał.
Yeah, thank you very much, Marek. I'm really honored to represent Poland. I have some good news and I have some bad news, unfortunately, for those who consider posting workers to Poland, right? And I'll be very happy to give you some takeaway, but I'm not sure if you will be very happy with this takeaway. Well, for many years, Poland has been considered as a sending country, all right? We see today the numbers, and that was leading us to the dispute regarding the business trip and posting of workers, with the most prominent examples that we also saw today during this speech. It seems that this interdependence has still not been solved, and their impact for social security is still unknown. So from this sending perspective, Poland, let's say that still some discussion needs to be taken. However, if I understand correctly, here I'm supposed to say you some words about sending or posting workers to Poland, and that will be also very interesting for you. And in reference to your speeches, the good thing is that collective agreements do not play important role, gently speaking, in Poland, right? So in contrast to Italian, in contrast to Dutch labor market, in Poland, collective agreements, they exist, let's say, they survived. However, from the posting perspective, usually it's not about this. So it's good to know that, okay, well, it's in the most of the cases, it is enough to observe the statutory minimum or average law in the area of remuneration. So if that would be not problem, so what Poland considered big dilemmas very recently, There's no doubt that in order to post workers to Poland, they have to apply in some cases for visas that refers to the third country nationals. And this is a daunting task to apply for a visa because posting the workers to Poland has been increasingly difficult due to visa refusals issued by consulates. Well, those reasons of refusal, they create great uncertainty for both workers and for employers and leads us to the situation not desired from the business model, right? So applicants, they have to justify the purpose of conditions of the planned stay in Poland, for instance, or there are some reasonable doubts whether the applicant will leave Poland until visa expires. Yeah, because of course we can imagine that many foreign workers are coming to Poland. They see that, oh no, I want to leave forever, and they're leaving Poland as quickly as possible. And this kind of reasonable doubts constitutes the grounds of refusal the visa. So we see many cases, for instance, from Lithuanian perspective, Lithuanian companies are trying to post workers, for instance, from Belarus to Poland, and generally even before this law was adopted, it had been rather difficult to apply for a visa in Belarus. Right now, it's even, let's say, more and more. It's kind of really, really difficult task. Well, so this is rather important to note that right to stay, right to go into Poland is an important prerequisite to be able to provide the services in Poland, right? So this could be also considered in the light of infringement of Article 56 of the treaty, if we consider this refusal of visa as one of the obstacle to provide the services, and this is also maybe that should be also the question to the ECJ, or Marek will make any other vote here. We will see, who knows what it can be. So very important first thing regarding the visas, and the second thing regarding the posting of foreign nationals to Poland. Again, new regulations, new prerequisites in order to apply for work permit that is dedicated for posting workers, including intra-corporate posting, right? Including intra-corporate posting. So under the new rules, several strict conditions must be met before a foreign employee can be posted to Poland. Firstly, it's about that the foreign national must already be employed by the foreign company during the submission of application. And this, usually the process of submission of work permits is, gently speaking, time-consuming. So, well, I know I had to add that these prerequisites might be difficult, and also from this business perspective, very important to take into account. Secondly, it's about formal status of an employee. So, in other words, the posting must be based on employment contract. That sounds quite reasonable, right? But on the other hand, civil contracts might be considered beyond the scope of this law. So I think that that's maybe another obstacle. And thirdly, including intra-corporate posting, new prerequisite, new law requires vertical capital links between the foreign company and the receiving entity in Poland. So in other words, the companies must have so-called parent-subsidiary relationship. As a result, postings that are rather typical also between so-called sister companies might be considered as not admissible if there is no direct financial dependency between this entity, so between this that sends the worker to Poland and those that is receiving employees in Poland. So to sum up a little bit this part, so for companies planning posting to Poland, careful preparation, clear documentation, and thorough understanding of both migration law, but also in case of intra-corporate posting, corporate structure seems to be even more important than ever. Thank you.
Thank you, Michał. To the pile of barriers that we spoke of yesterday, we have another one. Thank you very much. I don't know how we go over them. Ladies and gentlemen, because we have postponed the lunch break for 10 minutes, we have a chance to ask one question to one speaker now. Thank you very much for understanding. So I go, before I think, no, there is one question. Yeah, go ahead, go ahead.
Thank you very much. My name is Andrea. I'm from Romania, and I have a question about Poland. So, just to clarify, if I would like to hire a non-European in Romania and then post him to Poland, should that non-European apply for a visa? This is what you said?
Yeah, if I understand your question correctly, so if you hire a third country national
in Romania,
in
with
Romania,
a Romanian residence permit for work purposes, and I want to post that non-European to Poland.
Yeah.
Can I post him just like that, or do that non-European needs to do something?
Okay, this is your question. Okay, so firstly, there is a question about their residence permit in Romania, because in the most of the cases, if they can stay in Romania, they can go to other countries for 90 days within the 180 period of time. So if this will be enough from this perspective, this is okay. But in the cases, if it is more time-consuming project, for instance, in Poland, so based on new law, then in the first case you will have to. I mean, not you will have to, but the foreigner will have to apply for a visa in Poland. I mean, of course, in Romania, but
yes,
or in the other country, but yeah, there's.
Which is in accordance with the Van der Elst case. So I guess after 90 days, yes. That was the one question. Thank you very much.
Visa and not work permit for 90 days.
Sorry?
After 90 days.
The question was, is it really about visa requirement and not the work permit? Well, if the person is legally, you should answer this. If the person is legally residing and legally working in Romania, then posting this third country national to Poland should not come to a barrier which requires the work permit. Now your question is, does the new law put that illegal barrier? Does it?
Yeah. So yeah, it seems that we have some new regulations, and they indeed they are contra the idea of posting, because of course posting was about to send the worker to another country without the work permit, without additional work permit. And we see that there are more stringent provisions relating to this work permit, and this should be considered in the light of the Treaty of the Functioning of the European Union.
As a barrier, yes. Thank you very much. Now I have good news. We will, after the lunch break, which will last 1 hour, we will split to separate rooms, and I numbered them A. This is room A. And in room A, we start with no staff, no pay, no way to care. And it's a report from and a discussion from the Mobile Care Project. And in room B, which is next to the reception, we will have the workshop by Kandem and Marta Zięba-Szklarska about how not to make mistakes when calculating labor costs. and then negotiating the price for your service. In room number C, which is just behind that wall, David Wensing will take you into journey to beautiful Netherlands for the details of posting of workers to Netherlands. Then after a short recession, no really big break, short recession, in room number A, that's this one, we will have the workshop by our knowledge partner, Vialto, and it's all about social security, taxes, and other pitfalls when posting within Central and Eastern European countries. Then in workshop room B, next to the reception, posting to Germany by Marius Tolenere from German division of Fragomen. And in room C, just behind that wall, we go to France with Agnieszka Paszkowski and DBA. And after the coffee break, we reconvene here for the last very intriguing session with Polish labor inspectors. And I'm so proud with this title. Trust me, I'm with the labor inspection. So don't be scared. This is just a rehearsal of what will happen when they come and knock at your door in real life. Now, a very important moment. Before we go to lunch, I would kindly ask you to stand up and come close to this stage. And if you can fit on this stage without making injuries, do stand on the stage. We need to take a photo. Please, please stay with us. Thank you very much. I announce break now, and everybody here.
Shall we remove the tables or?
Moderator in the center, please.
Oh, the ding. Ladies and gentlemen, good afternoon and welcome to the session devoted to some findings of the project that we were carrying for 2 years now. Project is called Mobile Care, and unlike the project of Frédéric de Vespelare, Postingstat, this one was not a research project. It was a project that was supposed to enhance the capacity of social partners to discuss and to create the legal framework for the future of the service of provision, for provision of care service, living care services. And we came across very difficult questions that need to be answered by the member states. So we've made some policy declarations and policy, well, advisory hints for the policymakers. But we also had a very vivid discussion between the social partners who were partners of that project. So this discussion is only touches only on 2, maybe 3 most controversial issues. It doesn't cover the entire sector. And let me introduce my guest, and I will start with a person who is not part of the project, that's Ada Zaorska, because the partner of today's session is also the Polish Association of Live-in Care Service Providers, and that's an organization of Polish employers in this sector. Radmila from Serbian Republic represents trade unions in Serbia, and Serbia is an interesting case because obviously it's a candidating member state. So all caregivers from Serbia fall into the category of third country nationals. Hopefully not for long, hopefully. Yes, and to my left and to your right is Cécile Jarnot from EFSI. This is the organization of employers and companies, organizations who organize and deliver various kinds of home services, including live-in care services. And this is a very big part of their activity. And Rebecca from Domina, that's an Italian organization, which is more of a research organization, but also an organization dealing with the convening the employers in that sector. And I will now, I would like to give a floor to Cécile, who will be leading part of this session, and then I will take over.
Thank you very much. Just one precision, it's Cecilia, not Cecile. So it's fine, don't worry. Just wanted the audience to know my actual name. Also, on your screen, you can see Leonore's name. She was supposed to lead this session. Unfortunately, she's unwell. So I'm taking the hard task to do it. I have her notes. She was well prepared. So I will mostly read. I apologize for that. But yeah, we will start. I think we have a presentation normally, if we can have it. The clicker is here. Perfect. So our speakers, you also see Frédéric's name. He's unfortunately not with us either, so it will only be us. I won't go too much on the mobile care project because Marek already quite well summarized it. We're now coming at the end of this project. It's ending at the end of this month, and this conference serves also as the final conference for it, the final moment to present our results. We've seen across those 2 years all the discussion that across Europe, the demand for long-term care is growing rapidly, mostly due to the population aging. Thank you. Which has further highlighted the importance of strong and resilient care systems. Care has become a topic of relevance discussion at the EU level, which with several initiatives in recent years, and it's currently one of the main priority for the Cyprus presidency of the Council of the EU. We still see that there is a lot of significant structural challenges. We've talked a lot about those in these 2 days, including the fair working condition, the shortage of workers, mobile workers, affordability of care for families, skills and professional development, and organization and social dialogue. As Marek mentioned, we want today to focus on the points where we couldn't find an agreement amongst the partners. We are unfortunate to only have 2 of our partners, but it was 7 nationalities and 7 nationals, so quite hard sometimes to find agreements, especially when we have so different culture and countries. So it will be this following format. I will introduce 2, maybe a third question if we have time. Both Radmila and Rebecca will comment on it. We'll propose a solution, and then I will ask you to vote on which one you preferred or you think that it's the most realistic, either in general or in your own country as you prefer. I'm not going to ask you to comment. So we'll first have the first question, then the second question, the same round. Then I will give back the floor to Marek and Ada for a bit of a conclusion. And hopefully we will have time for some question, comments, a bit more of a debate at the end. All good? Perfect. So we can start with our first topic and our first question, which concerns the financial sustainability and undeclared work in the sector. We know it, undeclared work remains a major issue in home care and is often linked to high cost for families and limited public funding. This raises a fundamental question. Who pays for home care and who ultimately bears its true cost? We need to consider the balance between affordability for families, fair wages, and social protection for workers, and sustainable funding for the sector. We discussed over the project the use of national tax incentives or deduction, potentially supported by the EU-level framework or funding mechanism to encourage formal employment in the sector. So my question is, what are the most effective ways to reduce undeclared work while keeping home care affordable and ensuring fair working conditions? Rebecca?
Thank you so much, Cecilia, and good afternoon to everyone. Thank you for the opportunity to participate in this Congress and to contribute to this discussion from the perspective of the Italian home care and domestic work sector. In Italy, care for elderly or dependent people is still largely organized within families, and home care based is often preferred to the institutional solutions. For this reason, domestic workers and caregivers are a crucial part for our long-term care system. In Italy, as I realized for the rest of the countries that participated to the mobile care project, one of the main reasons for informality, so for irregular work, is the financial burden faced by the families. Families, in fact, often rely to caregivers because public long-term care services are very limited, especially in my country. But also the cost of employment for a domestic care worker can be very difficult to sustain over the years. For this reason, we found out that financial support for households is a key policy tool that we agreed on during the project. So we saw that measures such as tax deductions, as Cecilia was saying, care allowances or subsidies that are linked to regular employment can be extremely helpful for families to support and employ caregivers legally. So we believe that all of these elements can definitely help reduce irregular work and kind of formalize the employment relationships in Italy and the rest of the countries in the European Union. I would like to say also in conclusion to this first question that another important element that can definitely reduce undeclared work is also administrative simplification. Because I don't know in other countries, but in Italy, bureaucracy is very long, is a very, very difficult process. And we have to remember that families are not companies. They are private employers who often have little experiences on labor regulations and payrolls procedures. So they definitely need a simplified process for registering contracts and paying social contributions, maybe through digital systems to encourage this formalization. Thank you.
Thank you, Radmila. Same question.
Hello. It's very I'm very convenient to be here today, and thank you, Marek, and the Polish Association to call for this meeting. And I represent a trade union of health and social employees of Serbia, and we are the bigger trade union in public sector, and we talked about public health sector and social care, and we have about 50,000 members in Serbia, in each hospital and in each social institution. The same problem as Rebecca said in Serbia, but my point of view is different. I represent caregivers. It's employees in social care, and from Serbia, a lot of women go to EU to give this type of care in house of people who need elderly care. And I will focus only on rights of employees. I think that is necessary to make a list of jobs and activities for contract. This list must include an emotional scale and must be created with components which mean the level of stress depending on the conditions of elderly users. For example, if a person is suffering from Alzheimer's disease and need care in their home, maybe that person has a pain and can be disoriented. And this emotional state must be included of this emotional scale and be part of a contract. Of course, we must look qualification and make a clear obligations in contract. And one suggests, if we want to reduce the salary costs of caregivers, we suggest that the pension contribution be paid in the country of origin at the salary level for these jobs in his origin country, because it would be a great benefit to them, because most caregivers don't spend their entire lives doing this type of work. And for example, in Serbia, if we have minimum 15 years of working time, you have rights on pension when you have 65 years. In case you give care in Germany, for example, or Italy, maybe 1 or 3 years cumulative, in case that families pay for pension in a Serbian pension fund, not in German pension fund, it is the cheaper for family. But it's very good benefit for person who give care, because maybe they have 13 or 11 years of work, and they can cumulative have a condition for pension. It is, for example, in Serbia, in institution for elderly care, the salary now about 500 to 600 euro without tax. We talked about netto salary, and for pension part plus 150 euro. I think that if you in Germany, that person have 2,000 salary, maybe if you pay tax regularly in Germany, it's be more. And we think that be good and enough reason to have that to adopt that suggestion. And of course, it's very important for caregivers to have insurance according for risk of job. It's not the same person with disability or people who need less of care. It is for first question. Thank you.
Thank you very much. As you can see, one question, but a lot of different options and a lot of different answers. And there are only 2 of them. Imagine us in Malaga with 7 national. And Marek, please.
Yes, because our German colleague couldn't be with us today. And I think in Germany there is a structural problem with encouraging the grey zone employment in live-in care services. And that structural problem is the care allowance, which is cash in hand to the family who needs this service, which basically means that they can easily spend it for undeclared worker. And on top of that, because the service is provided within the household, a private household, the German authorities, control authorities, have limited access to the private households, so they have limited possibilities of really controlling who lives there and what they do. On the other hand, of course, if you have a German neighbor and he spots someone else in your in your house or surroundings, they might be willing to ask the authorities who this person is. So that puts a little bit counterbalance to the problem, but generally, I think that the weakest point, and that was also our German colleagues' opinion, the weakest point is that the money is paid directly to the family, which means that it is not controlled how it is spent, whether it goes to the declared work, to legitimate service providers, or to undeclared work. And one more driver of undeclared work, and if I may direct this question immediately to Ada, and I apologize, the translators, I will change into Polish for easier communication. Jednym z najsilniejszych
One of the biggest reasons for people to leave their country to work abroad is the differences in salaries. But there is another driving force behind this phenomenon, and that is debt. In Poland, many women are paying back debts incurred by their husbands, and very often they look for work abroad in the form of undeclared work, because the moment they work legally, this will be immediately taken by the court to pay back the debt. Now, this might not be the majority of undeclared workers, but it is an important factor that is a driving force behind this system of undeclared work. Now, Ada is a hero of mine. She has done something that employers don't normally do. She helped someone pay back those debts in order to make sure that the caregivers can work legally. Can you tell us how this is done? Thank you very much. I'm blushing after what she said. But yes, this is true. Caregivers very often go to Germany because they want to escape the Polish insurance system. They want to become transparent or invisible to the Polish courts because they have to pay back those debts. Now, usually they work in the grey sphere because they don't want for their revenue to be seen in the system by the debt collectors. We had situations where there were some ladies working and there was a bailiff's order that came to our company. One particular time, the bailiff's order was for a very large amount. So what we did was we found a German law firm where they spoke Polish, and they undertook the task of helping declare consumer bankruptcy for those people. So the precondition was, first of all, for those ladies to be there in Germany for at least 3 months without a break. After that, the documents were filed with the court, and in the meantime, the bailiffs were at work in Poland. But in Germany, those ladies were able to obtain the consumer bankruptcy status, and that was sent to the Polish bailiffs. There was quite a lot of shouting on the side of the Polish bailiffs. They wanted to negotiate something, but they failed. And then those ladies were able to come back to the labor market and pay all the taxes, all the national insurance contributions, and so forth. Now, the limitation for them is that for the next 6 years, they are not allowed to have a credit card or to get any loans. But I think it was worth it, and I think this is a way out. On the other hand, I'm not really surprised when it comes to the customers. Let's say they can pay 2,500 when they hire a professional company, or only pay 2,000 in the grey sphere, cash in hand to the caregiver, then they will choose the latter. And very often these ladies are quite young persons and they don't really care about saving for their retirement. They think everything will be fine. And then the moment comes when you want to retire, and suddenly it turns out that your retirement, that your pension is pitiful. I had a situation like this in my family. One of my cousins worked in Italy for 15 years without paying any national insurance contributions. And right now she has retired and she started worrying how she will survive. So long as these people still have the strength, they keep working, and then after this bankruptcy procedure, they make sure that they now pay the insurance contributions. You can also pay a bit extra on top in Poland to add money to that account in the Polish system. One of our caregivers is 81 years old, and she still wants to work because the pension she is receiving is so small that she wouldn't be able to survive without working. So now she's been with us for 13 years, and she's basically trying to set aside some money. And this is what it looks like when you work in the gray zone for many years, and many people don't realize that.
Thank you very much. We switch back to English. Cecilia.
Take this one so you can. Thank you. Not sure how to follow since, after your testimony, thanks a lot. Thank you also for mixing all our presentation and our plan. I love it. But it's good. It's make the narrative much better. I will still ask you to vote. I hope you can remember everything that was said. And I will expand a bit also to add a bit more of what was discussed all throughout the project. So, possible solution to answer this question: expanding tax deduction or voucher system for families. That's the first option. Increasing public funding or subsidies for home care. Second option. And I will move to the simplification and a bit more of a transparency through the contract for the third option. You can vote for several because it's not an either or, because they're quite different. But who thinks that the first option would be the more realistic or the most practical to implement? You can just show of hands. Thank you. For the second option, increasing the public funding, a bit more options, a bit more voting, and around the simplification and more of transparency in the contracts. Okay, I think the third one is the winner.
I think the second.
I saw more hands on the left for the third, but second, third, they were all voted on, so all good options. But you can see how it's hard to come up with one single solution. I will now move on to the second topic and the second question. So the second topic focuses on one of the most complex issues in live-in care: working time and rest periods. Unlike other sectors, live-in carers live in the workplace, which creates unique challenges, and we already discussed it a bit. So how can we clearly distinguish working time from personal time when care services may be needed 24 hours a day, ensuring adequate rest period, fair working condition, and compliance with labor standards remain difficult in a continuous care environment? So my question is, what practical solution could help balance the need for continuous care with the protection of carers, working time, and rest period? And Radmila, you want to start?
Thank you. We know that very difficult today have one caregiver and one user. In future, and think that is the worst because our nation are elder and natality is small. Maybe we can plan our future in this field with migrants, but it is not a secure solution because we don't know who and when came to our countries. In the long term, it is necessary to harmonize the model of home care for the elderly with the possibility of finding of caregivers. I suggest a model according to which 3 or 4 users stay together, live together in the same house, and the caregivers take turns or shifts. In that case, we can organize 2 or 3 caregivers for 4 people and have 24 hours care, and it's be more convenient for families. They live in the same house, and we know that so expensive energy today, and will be maybe more. And they can share for salary for caregivers in that case. Is not institutional frame, but is the some manner to survive with inadequate number of caregivers, and take rights for caregivers that they don't work 24 hours without paid, and they have rights for rest, and it's I think the possible in future, in no so far future, the next years maybe. Thank you.
Perfect. Thank you so much, Radmila. I actually really agree with you. We spoke about this issue so much time in our Malaga meeting for the mobile care. What you just described, so kind of like a co-housing option, it's super interesting, and it's an idea that particularly stuck with me. So the idea is to have 2 or more caregivers that can rotate shifts, and they can get the rest they need, and the person can also receive care full-time, around the clock. On top of that, I also believe that clear contracts are essential, because working hours, rest periods, and responsibilities need to be spelled out. They need to be clarified before starting the work. Because this protects the caregivers, clearness protects them, but it also gives family kind of like a predictable plan for organizing the care. We also need to remember that caregivers can't replace public services. Sustainable home care really depends on better connections between private caregivers and public support, such as home nursing, as we were speaking about, community services, and daycare centers. So through the project, we came to kind of like a conclusion that also technology can be a tool that can help this factor, because, for example, remote monitoring, telecare, and simple digital tools can make life easier, and they can reduce stress for both the caregiver and the person who is being taken care of. At the end of the day, I think that what matters most is cooperation, of course, between families, public institutions, and caregivers, they all need to work together. We need to support families in organizing care and making sure that caregivers have fair working conditions. This is very crucial for the EU level, because when we get this balance right, home-based care can be both sustainable and dignified. So people get the care they need, and caregivers are respected and protected. Thank you.
Can I cut in?
Yes, I was going to tell you to do it because I was sure you would do it.
Thank you very much. Now I'm going to represent Malta because we had partners from Malta, and one of the experts was from the academia and the other was from trade unions. And the partner from trade unions, he said he was very strict. I mean, we have labor law. And if there is a need for 24-hour service, and in some extreme cases, there is a need for 24-hour service. In most cases, the care is just few hours a day, but it is very difficult to distinguish, to make a distinction, what is your working time and what is your free time if you work in the place where you live. And this is not only for care services, this is always when you work from home. It's difficult. So he said, no, if there is need for 24 hours service, you need to pay 3 persons 8-hour shifts. And the other experts, the economists, he said, okay, but to imagine an old person who is faced with 3 different persons who take care of him or her. This is kind of torture. Already now, when the caregivers are changing every 3 weeks, every 6 weeks sometimes, there is a big fuss about, well, I liked that caregiver better than this caregiver. Now imagine doing this 3 times a day. Conclusion is, of course, not any particular solution, but I think that Radmila's idea to make sure it's not institutionalized care, it's still home care, but you have a community of care recipients, which is organized by wider local community, and then the service providers and the caregivers come in turns. So it is more of a cohabitation of community, and without the wider community, the involvement of the wider community, I think it's not possible to organize it.
Thank you. And you touched on the co-housing that Rebecca was mentioning. So in that case, I think both of our speakers said the same thing in different words, perhaps, but the two are the clearer contractual arrangement defining working and rest time, and the rotation system with multiple carers / co-housing, wider community to support this. So again, turning to you, the audience, which one of those 2 options do you think is the most realistic, realizable, maybe in the next few years, as Radmila was mentioning? So option 1, clearer contractual arrangement with a clear definition of working and rest time. Who's voting for that one? 4. Perfect, thank you. And the rotation system with multiple carer or a co-housing system. Yeah.
Also 2.
2 and 2.
But it means that you have a third option. What is it? There is no. Yeah, the live-in care, 1 person, 1 carer and 1 recipient. Yeah. This is how it's organized now.
Przepraszam, skoro znowu przechodzimy na polski.
So we're switching into Polish again.
Prowadzenia.
I've run my company for a dozen of years now. Now, I know one thing. The older you are, the more you want to stay at home. You don't move old trees. You look after them. I know that a younger generation wishes to put 3, 4 people into one house. In theory, it's all beautiful, but bear in mind that these are people that haven't known each other before. They have their own nature, their different behaviors, customs. They have their animals. And now they are to go to 3, 4 different people they don't know. And God forbidden, there's conflict between these people. Can you imagine? It's pure hell. They're these elderly people close to their final days, and they are to be faced by such stress. You know, when there's a care recipient and caregiver, very often another person goes, a kind of mediator, and asks, what time would you like to have breakfast, lunch, and dinner? When should there be some time for the carer to take rest? Perhaps the family might come, and then the caregiver might have the whole day free. So then the care recipient feels that they control the situation. And as many hours as there are in the contract, the services provided, then it is beneficial for the care recipient. But if there's any conflict, there's the company to solve it. There are competent people who might be sent and, resolve the situation. So, okay, if you don't like your caregiver or if you don't like your care recipient, we might change something and there might be a solution found. Even if we had the worst cases, emotionally, physically, in the end, we were able to find the right caregiver to the right care recipient. So even the most difficult care recipients could find the right caregiver. Yes, please. Thank you. I'd like to refer to what Ada has said. I agree, okay, you're right, but bear in mind that in Germany, well, this is the market I know, this Wohngemeinschaften trend, where senior citizens get together in nursing houses, there's a very strong trend because elderly people do not wish to be alone. They very often live together. So I wouldn't fully reject this idea. May I? Yes, if it's the choice of a given person, all right. But you mustn't force everybody to follow such a solution.
We consider the cohabitation solution, and it's not institution, but a private initiative. Then how do we solve the housing problem? Because these older people, they usually have apartments. Maybe one of them has a house, but you have to house together, let's say 4 older people and 3 caregivers. So where do you find the place to put them together, and whose place would it be? Like one of these older people who would be the owner of the place, so he would probably try to force the rules of living on the others. And also, if it's a big city, then usually you only have smaller apartments. And then I don't see the solution how to organize it. But I'm not a practical. I don't know the practical side of this, so maybe you can tell me how it works.
Shall I answer this?
Yes,
Yeah,
you can
yes.
start, and then if anyone wants to come in.
Well, of course, it's like Ada said, there is no forcing, so it's impossible. So one problem is, do you give the old people the preference? And most of them would choose to stay at home, of course, and to be one-on-one. But some of them feel that the worst phase of being old is being alone, and that's actually much more important function of the living care service to keep the company. And for those people who are not, very sick or incapable of moving, making daily centers would relieve the caregiver who is living at home from part of her duties. So she could enjoy free time then when the person is in the daycare center, which forms a community. But I understand that the second problem that you mentioned is infrastructure. And in the big cities, indeed, that would be the burden of the public services to provide this, which is very easy because we have no children. So what do we do with the kindergarten? We let the old people to play with the toys there. So I think that infrastructure is there. I know it sounds funny, but this is something that we can reconcile with relatively low cost, but not without a cost. I agree with your last answer that the public co-financing of the services is absolutely necessary. So that's my humble answer, but there are no perfect solutions here. Would you? Yeah.
I just want to complete what you were just saying, a bit outside of the care aspect, but on the housing aspect, to solve a bit the housing crisis that we have. It's a big topic in Belgium. I'm living in Belgium at the moment. One of the solutions they found was to house students and young people, well, not too young, but young professional people with elderly people. Obviously, they don't need the care and they're not doing the care because they can't do it. But that's already one step in the good direction for the houses crisis that we're facing. And I think it can completely work with the day caring in-house and having the person at night that can deal with emergency, let's say. So just to wrap up there.
And one last...
Radmila, I wanted to say something.
Okay, it's only one idea. It's not the wide use case, but it's not impossible in total. Because, for example, have a very big house and 3 bedrooms, thinking about needs of users and their conditions. And maybe my mother stay on the bed and don't need any moment care. And the other is can moving the other person. They need to somewhere who prepare meals and clean and look for her medicine needs, call family or medical staff, and is of course it is not institution, and we must combine a person who accept this idea. Thank you.
Thank you. And Rebecca, I think you wanted to talk a bit about another initiative.
To respond to your question, which I think it's very, very good question. In Italy, I had the honor to participate to this project in the north of Italy in Trieste, and I could do a study visit in Trieste, and I had the possibility to see a real example of co-housing in Trieste. It's like a really nice initiative made by the municipality of Trieste. It was founded by Fondazione Annanian, which is a no-profit foundation, and I could see how they transformed some kind of like old building into a perfectly adaptable house for elderly people where they have any kind of service they need. It's like apartments, small apartments, where maybe it's like 3 bedrooms, 4 bedrooms, and it's like this for the entire street. So that is the only example that I can give to you in Italy of like a very good cooperation that they had in the town of Trieste. Of course, it's not a big city. If you've been there, you will know it. It's much easier when the municipality, the town is smaller. It's much easier to create such initiatives.
Just a second. This was not the end of our policy recommendations. And they are not competitive with each other. We just didn't want to list all of them during the workshop. We intentionally picked the ones that are hard to realize or controversial, and that is the one. But one of the best practices that we've noticed that is already applicable is to make the very clear list of tasks of the caregiver and to make sure that the family, especially the family of the care recipient, does not exceed this list. And then the legal problem that we have in Poland would be it is impossible to make a shredded working time along with the Polish regulations, with the Polish labor code. So that's the problem, but it is possible to condense the activities of the caregiver in a shorter period of time than 24 hours, even though the caregiver is around. So the most controversial part is when this person is in the house, is she on duty or not? And my answer is, let's assume she's not on duty. Let's assume she would be paid extra if she's called during her free time. And it's just like in other types of work with the overtime. The problem is who controls it, because the employer is far, far away, because we're talking cross-border. So it's really difficult to set it up as a ready solution. And please be aware of people who offer simple solutions to very complex problems. Thank you.
I think there was a question.
Bardzo fajny pomysł.
A very good idea. This is how it works in Germany. There's a kindergarten for the elderly. So this daycare is provided. So if family cannot provide care for a family member, the carer puts the patient on a bus, then takes them to this kind of kindergarten, and then the person stays there the entire day and then is taken back home. But who is responsible for such a patient? You know, it's good when it is the operator of the kindergarten. If we talk about houses or flats, who is to be responsible? Should we have agreements with the flat owners, the families, or the patients, the elderly who live in a given flat or home? And now, if there's a person with dementia, or suffering from Parkinson's disease. You know, there are different types of dementia. A person might be in stupor, or might be aggressive, or might be unable to look after themselves, you know, brush their teeth, or find a spoon or a fork. I'm not sure what the situation in Belgium or Italy is like, but, well, diseases are similar after all. If a flat has 50 square meters and there are 2 rooms, how would it be possible to put several people there? Well, I know that the solution might seem interesting because then you can save costs. But how can you choose whether this care recipient A fits care recipient B and C? And if you have several carers, so one is from Romania, the other is from Ukraine, and the third one is from Poland, even if they have to provide care in turns, there might be conflicts between them, which, of course, might have an impact on the professionalism of care they provide. Well, you're speaking about details. We are looking for general solutions, for some strategy. You're talking about tactics. Let's find the path that we might follow so that we provide all of us, all of you here, care in the future. Well, you might be 20-something now, but really, in a moment, you will be 70 or more. Time flies, believe me. So before we speak about details, let's find some directions, some solutions that the elderly will accept and society will accept. And only then will we discuss how to put it all in practice. We have time left for one last question. Okay, I want to speak about these basic directions. It seems to me that this solution can be used in an urban area where there's greater population and more dense development. I know it is generally adopted that in rural areas, large families live together and families provide care. But it's all gone now. Social structure has changed. So the question is how to provide such solutions for areas where there are fewer people and where to find people who'd like to live and work in such areas. I'm not talking about depopulated areas, but I can imagine that it's easier to find someone who will come from abroad and provide services in Warsaw, Kraków, or Gdańsk than will go to a small village somewhere in the countryside. I believe that there's one misunderstanding here. It's not an alternative to home care. It is to complement what is already being developing on the market, but within very unclear legal regulations. Of course, the condominia are possible only where they are possible to exist. No one wishes to introduce it instead of providing home care provided by one person. You know, our discussion started from this question, how to balance the working time and time for rest for a person who provides service in the house where he or she lives. So the solution presented here is one of the solutions. Of course, it's not the best one, but it's simply one of the solutions. Let me now give floor to Cecilia to sum up this session.
Thank you. And I think we could stay here forever and discuss, but I see that we're already well past in the red, so I will just wrap up and I will be very quick. I think we need a second project to continue the discussion, and we need to come back next year to continue the discussion. Thanks a lot to our speakers, to our panelists. Thanks a lot to the audience for your question. Very interesting, and well, enjoy the rest of the Congress.
The stage for the
yes.
Thank you.
A, no, chodzimy tam zostanie. Dobrze? Przecież już.
Mógłby nam pan zrobić zdjęcie?
Ale oczywiście, tak?
Nie, teraz. No,
Potem już
no wysłane jest. Pan nam powinien połączyć się. Czy to jest to, nie?
proszę sprawdzić, czy odpowiada.
Czy to już jest ta prezentacja? Możemy zobaczyć?
Leci. Niestety muszę, nie jestem tego właśnie pewien, nie dostałem.
Nie za 7 minut wejdzie. A nie wiem, nie, że mamy godzinę. Teraz skończyło, teraz
Wyświetla się. Ale jest pan...
Ktoś tak odsuwasz.
Ale z jakiegoś powodu się nie wyświetla. Chyba już mamy prezentację, więc myślę, że możemy zaczynać. Bardzo serdecznie.
Right, I think the presentation is up, so we can get started. Welcome to the workshop, and I would like to tell you a little bit about our work in Central and Eastern Europe. We want to talk about the responsibility of the employer, immigration issues, taxes, and other obligations on the side of whoever posts employees in cross-border mobility. It's my pleasure to chair this workshop together with my good friends and colleagues from Realtor Partners. And all of my colleagues are advisors when it comes to employee mobility. Now, what are we going to talk about? First of all, we want to tell you something about the latest trends in mobility. We will tell you what is happening when it comes to the legalization of foreigners working in the region, personal income tax, and also other tax issues that can arise when it comes to cross-border employee mobility, social insurance, and other obligations of the employer. And we are going to tell you something about some things that are important from the point of view of effectiveness and efficiency when you post employees or when they are posted to your country. And we are also going to discuss a small case study to give you an idea of how this sort of posting can work in practice and what risks can happen. So let's begin by working globally in our region. When it comes to cross-border mobility, as we can see, 30 to 40% of business trips in your companies are short-term trips. So this is not your typical posting for 2 or 3 years. It's just a matter of an ad hoc project that is happening, and some employees are going to do it. Technology is helping us a lot these days. Sometimes the employees want to work from home, and there is more and more work from home in the region, and the employees like it very much. And it has some benefits, but it also has some impacts on the efficiency. Next, we can see that there are higher and higher expectations from tax authorities, national insurance authorities, and others. And technology is also a supporting tool here that makes it possible to inspect and audit and verify that everything's in line with the law. Now, the biggest risks is actually especially to do with the short-term phase when an employee only goes for a few weeks, and we don't really acknowledge that there is a risk connected with it until it's too late. Few companies actually have any registers of comprehensively monitoring who goes where and for how long. For example, there have been cases a few weeks ago when the war in the Middle East started, when companies weren't even sure where some of their employees were, let alone being able to help them come back to Europe. Now, for current trends in Central and Eastern Europe, there is more and more demand for experts, and that makes cross-border mobility of employees a must. There are regional projects, and due to cost and transparency issues, it's very often easier to do them locally, whereas bringing experts from outside of our area is much more expensive. Secondly, there is a pressure from the regulators. All of us have participated in a number of sessions on the common market and immigration issues, and there are barriers everywhere, it seems. It's getting harder and harder to address all the risks, and navigating your way around these risks is also harder. Very often, we suddenly learn that there is a project to be done. It starts tomorrow. It's abroad. We have to take part in a tender or place a quote, because obviously that means revenue for the company. But only after we do it do we start thinking whether we actually have any experts in that particular in the particular region, and whether we can post employees to do it. Now, this is a risk map in terms of migration, taxes, social insurance, and such. The so-called tax center creation and other elements. And this is something that few companies think about. These risks remain unquantified. So when you look at the cost of mobility, and that can be a very big risk, this is very often not considered. The same goes for all sorts of notifications and other obligations you have to meet. If you don't meet them, or if you meet them too late, that is going to be a risk for the business. Now, this is a message that seems to get across to everybody easily. These are 5 biggest mistakes that companies make most often when it comes to mobility. So let's have a look at these 5 items. Do we have a process for that, or do we act on an ad hoc basis just because there is a new project coming up? We have to send a group of service personnel or experts to a place that bought our products 2 years ago. So basically what we say is that a bunch of service experts have got to be there in a bit. Secondly, no mobility-related position in the company. This usually is relegated to the HR department or the finance department, and we try to find someone who's going to do it. Number 3 is underestimating remote work from abroad. Sometimes we have employees who come from abroad. We make some room for them at the office, give them a computer, but we are not sure what else we need to do. Are there any health and safety related obligations, for example? Number 4 is this assumption that going abroad for a short time is safe, doesn't pose any risk. Well, I'd say that the risk of detection might be small, because immigration, insurance, and tax offices might not have enough time to catch us out while people are working abroad, but the risk is there. It's just the probability of the risk materializing is rather small. So we need to be accurate when you talk about it. And finally, a lack of control over the costs of mobility. We pay the employee the usual amount, we move them to a different country, then when it turns out there are some taxes to be paid, we do that. And maybe we have to pay them more because the minimum wage, say, in Switzerland is higher. And at the end of the day, we're not quite sure whether the price we quoted the client for is sufficient to cover all these extra expenses. And all of this boils down to the fact that we very often don't have any processes for that, and we act on an ad hoc basis. Now, this is a very typical mobility request in our region, and we are going to discuss taxes, insurance, and other stuff. But this is an example, a case study of Olena. This is something the experts are going to be talking about. Now, Olena arrived in Poland in 2025, and she works in IT. She has a residence permit, the so-called single permit, as we call it in Poland, so she is allowed to work. And now I need to post her to the Czech Republic for 3 months as part of a project. Now, during the stay in the Czech Republic, she also has to go to Hungary for a bit to work remotely. Now, her employer has been expanding into Hungary, and is planning to open an entity, a company in Hungary, but due to business reasons, this has been postponed. So as we go through this workshop, we are going to try to show you what the current trends are, what popular pitfalls are, and what can be done when a request like this comes to your desk. And let me now give the floor to my colleague. Right, let me take control of the slides too. A very warm welcome. It's a pleasure to be here. I would like to discuss immigration trends in our region. So that's Central and Eastern Europe. I'm not going to read everything. We don't have enough time, and I'd rather leave more time to my colleagues for the case study. But there are two items in particular I would like to draw your attention to. If we were to define CEE immigration trends in a nutshell, I would say there is more and more restrictions. It is estimated that the population of productive age people in CEE will be down by 5 or 10% by 2030. In Poland, it could be 2 million fewer. Actually, yesterday, 3 million was mentioned. In this context, what is happening with the migration provisions seems to be going in the opposite direction. And what I mean is that there are more restrictions, not fewer. More difficult access to local labor markets is one thing I would like to draw your attention to. Some countries include limits or caps, and they introduce even more stringent regulations when it comes to foreign migrant workers coming to the region. Secondly, there are more compliance-related obligations on the employers. What seems to be happening in the region is that the employer is placed at the heart of the migration system. Not at the beginning, not at the end, but right in the middle. And by this I mean that there is a lot of all sorts of obligations on the employer before they employ a migrant, during the employment, and afterwards. Now, we want to talk about Poland. Among other countries, for example, the Czech Republic has a very similar idea to what we have in Polish about the notification about employees that are planned to be employed by us, and the sanctions are quite heavy. And there seems to be more and more cross-checks happening before a permit is issued. The authorities check whether the employer and the employee has met all the obligations vis-à-vis taxes, social insurance, labor law, and such. So these are just three. There are actually more trends than this. And it's not that Poland is particularly special when it comes to this. What we are presenting here is quite representative of the CEE region. Our colleagues from other countries tell us the same. It seems that all of these countries follow this trend of being very strict about all these regulations. So the approach of the legislator and then the regulators, the authorities, the approach is very strict.
Yes, I agree. I'd like to take you on a very quick journey through 6 CEE countries. And I'd like to show you in a nutshell what immigration regime looks like, what the greatest challenges are, during this Congress, we're talking about the barriers we'd like to take down. So I'd like to show you several such barriers in these 6 countries. And I'd like to tell you about the most recent changes in immigration law in individual countries. Let's start with Bulgaria. Now, what do employers who wish to employ TCNs in Bulgaria have to face? Well, in Bulgaria, there's a shortage of human resources, but they also have very many regulatory barriers. When it comes to processing of applications, you have to wait from 6 to 9 months to be able to employ an employee from outside of the EU. Some of the process is carried out in Bulgaria, some of it outside of Bulgaria. So the process itself is quite fragmented. And it actually resembles the Polish migration process. Now, when it comes to Bulgaria, I'd like to add one more thing. We associate Bulgaria with a country that's cheaper. So labor force is cheaper, remuneration is lower, so the cost of remuneration is lower. But because the legal system there is so complex, this country is actually expensive. So yes, today I will speak a lot about costs. So even if you intuitively think that a country is cheap, then because of its complex processes, it might be quite expensive if you want to comply with the law. Yes, so the cost of employing the employee then becomes high. And also, different permits, residence permits, qualification certificates, they are expensive too. Now, Bulgaria in 2026 has introduced this digital nomad visa for third country nationals who are employed by employers, and you can get this visa for 12 months. It can be extended by another 12 months. So you can live in attractive areas, you can eat well, and use this 10% tax. So yes, I'm leaving you, Joasia, room to speak about it. So Bulgaria will definitely benefit from it when it comes to tax collection and also by attracting talents. So it gives itself a chance to boost its industry. Okay, let's move on to Czech Republic or Czechia. So there you have standard procedures similar to the ones we have in Poland. So the processing time of applications is around 5 to 6 months. What they have that's interesting is a fast track, but this fast track is 3 to 4 months. So there's no such a huge difference, and you also have to fulfill certain conditions to be part of this fast track. So you have to have a given number of employees. Your company must be at least 2 years old, and so on. And when it comes to Czechia, they have huge requirements when it comes to documentation. So, for example, the certificate of being clean in criminal terms from the countries where you stayed over the past 2 years. And of course, the appointments with embassy, well, it's not easy to get them. Now, let me ask about Olena, this Ukrainian that we sent for 3 months to Czechia. Well, by principle, van der Elst works. So this work permit is not required, but van der Elst works, but not in all areas. You need to know what Olena will do. So optimistically, I might say that she won't have to get an additional permit. But when it comes to mobility request, you need to come to Czechia with this document testifying that you were not punished in any other country. Now, there are 25 different reports in Czechia, but as of the 1st of January, they have combined them into one report to make it easier, reporting system, so to make it easier for entrepreneurs. So yes, in Poland, you need to have this copy of employment agreement before employment starts. And in Czechia, it is the same. And the fine for miscompliance is that this work is seen as unregistered and you have to pay 120,000 euro for lack of notification. It's as if, you know, the regulator just put this typical password that people have on the computer, 123, 123,000 euros. Yes, in Czechia, if there are 3 infringements of law, then the permit might be revoked. Now, let's take a look at Hungary. There's a high demand for seasonal workers and highly qualified workers. Hungary has increased high restrictions for workers to obtain permits. So, on the other hand, you can get a single permit within 2 or 2.5 months. Well, it isn't very short, but in Poland, you have to wait for at least 12 months. And the main challenges when it comes to Hungary is, for example, accommodation. So before you apply, you need to have accommodation, you have to have all your documents filed, and the fact that the system is quite complex. When it comes to recent amendments to the immigration law in Hungary, there haven't been too many, because Hungary went through an immigration reform in 2024. And this is what they stick to. So I just want to draw your attention to the fact that these certified signatures is something that Hungarians pay great attention to. But because the interpretation of the law on citizenship has changed, families now have a problem. They have restricted access to labor market now. Now, if you wish to, or if you think about employing TCNs, then Hungary are this lonely island where you can do it quite quickly, but not cheaply. Okay, what about Olena? Well, the situation of Olena wouldn't be bad because Hungarians have confirmed that remote work from the territory of Hungary, unless it is for a Hungarian employer, can be provided without the necessity of obtaining a work permit. Yes, but in our case, you know, this Polish business was already developing in Hungary, right? Yes, so you should have these things all cleared up. Now let's move on to Romania. In Romania, this process is composed of multiple stages, so it's partly done in Romania, partly elsewhere. There are various requirements depending on different migration paths. However, what's quite unusual is this one-year cap on work permits. So it's 90,000 this year. So it's 10,000 less than previous year. And last year, this cap was reached already in December. So it's not very optimistic, speaking from the Polish perspective. And also you have to wait from 6 to 8 months for the necessary permits. But Romania has a different idea here. So for some time they have had some changes in the laws. So there's a third or fourth amendment to the law already. They believe that it would be good to employ the so-called permanent third country nationals through employment agencies operating in the territory of Romania on the grounds of a visa DAMA, and this would mean additional obligations for employers. So first and foremost, they would have to log in to a dedicated online platform. They would have to present employment contracts with detailed information on the working conditions, accommodation, and so on, have an agreement in Romanian and in the language of this person, and also provide an employee with a Romanian language course and support them in cultural adaptation. So yes, in this Polish migration policy, this is already being discussed. Yes, but there's no legislation on it yet. So, similarly to Romania, we have also created this list of deficit professions. So yes, Romania already has such a list of deficit professions. One more thing that should be highlighted here is that in Poland, this process includes multiple steps. So you need a visa, work permit, residence permit, and so on. And Romania wishes to have it within one single process, as it is done in more civilized countries. So yes, they are working on it so that this process is faster. Okay, let's now move on to Slovakia. In Slovakia, the whole process for a TCN lasts from 2 to 5 months. But Slovakians say that red tape there is huge, it all lasts too long, there are problems with arranging appointments to obtain visas. So Slovakia is currently working on this system of booking visits. They have introduced a system of codes, but it doesn't work very well, unfortunately. But they allow for applications to be filed in different places than the place where you reside. So, for example, you don't need to live in Bratislava, and you don't need to go to Bratislava to file an application. So yes, our colleagues from Slovakia asked me to highlight this. I won't speak too much about Poland because, well, we have discussed Poland for 2 days now. Now, in our migration strategy, we have the slogan, have control and mitigate risks. So we don't allow employees to work under certain visas. We restrict access to labor market, and we impose greater obligations on employers. When it comes to the key changes that we are all aware of and that we've been hearing about since yesterday, well, what we are waiting for is true digitalization of the system, and we are all waiting for this famous MOS 2.0. Very few of us know what it is really going to be about. We don't really know what challenges we are going to be faced with. But yes, we are trying to digitalize this system, hoping that it will only facilitate and accelerate the process. Well, let me only add that the ZUS, or the Polish National Insurer platform, was presented here in great detail before lunch. So, yes, the system that we are talking about is something that we should have in 1 month's time, but we have no idea what it will look like and what it will mean. Okay, now I believe it's time for Jasia to speak about tax issues and mobility of workers. And let's also bear in mind Olena. Well, we all know that 2 things certain in life are death and taxes. So I want to speak about trends in tax changes. I want to speak about minimum wage, also about changes in individual CEE countries, also about the so-called tax bet risk. And here I want to speak both about corporate income tax and personal income tax, and also about the system that's used by certain companies where you have to make sure that the tax paid by the employee is neither higher nor lower than in the country where he is posted to. Now, when it comes to CEE countries, a huge change was introduced in Slovakia. So now they have even higher taxes than they used to have. I will speak about it in detail in a moment. They have also, they now have greater restrictions when it comes to shadow payroll, for example, or the growing costs of contributions. There's also the issue of remuneration transparency. Maybe this is not something related to taxes, but to remuneration. And, well, our countries will also be obliged to introduce this. There's also the issue of tax information exchange. So it's not that I know only about the taxes I pay and my office, but also offices, tax offices, they exchange this information.
And there is a need to attract talent to the countries of Central and Eastern Europe. As we know, we don't have enough employees in Poland, and there are tax solutions, the aim of which is either to bring back the people who left or to invite and encourage people who've never been to Poland before. But there are some obligations and sanctions related to it. So let's say we have an employee who moves between these countries. And first of all, there's the minimum wage you have to meet. We also give you the average wage in the right-hand side. In Poland, both the minimum and the average wage is the highest. So when you're planning the posting of employees, you have to bear that in mind. That will impact the overall cost of the posting. I'm not going to read these average and minimum salaries, and these are the tax rates. Romania, with a very nice linear 10% rate. There are 3 countries in Central and Eastern Europe with a linear tax. A few years ago, the situation was even better, and there were more countries with a linear tax. These days, there's a trend to have a progressive tax. In other words, the more I make, the more tax I pay. We also have what is known as the solidarity contribution in Poland. If we earn more than 1 million zlotys, which I hope everybody here does, you also have to pay 4% extra. Right, so we've got Bulgaria, Romania, and Hungary. And the first 2 are at 10% of single rate tax, and Hungary is at 15%. In Poland, the lowest rate is 12%, and if you make 120,000 zlotys, how much do you effectively pay, taking into account the tax-free amount? Effectively, it's about 9%. So if you're making up to 120,000 zlotys, you're actually paying 9% effectively. If you go above 120,000, you will be paying 32%. And we also have Czech Republic and Slovakia with progressive rates. These are the 2 countries that used to have a flat rate, a single rate tax. They used to have a linear 15 in the Czech Republic. Now they added 23. In Slovakia, it is now from 19 to 35%. So that's a significant growth in terms of the tax rate. Now to discuss the other countries. In Bulgaria, there's the switch to the euro, and that will impact wages, taxes, contributions, and all sorts of document-related requirements, and the transparency of wages directive, which is coming into force, and the equality of pay between genders. Now, if we are posting an employee to Bulgaria, what happens with the taxes? Let's say we need to pay the personal income tax in the other country, in Bulgaria, then who should be paying the tax? Should it be the employee? It should be the Polish employer, or maybe it should be the company in Bulgaria that the employee is being posted to. And this is the so-called shadow payroll, which is when we keep the payroll on someone else's behalf. Formally, Poland remains the employer, not Bulgaria, but the Bulgarian company that the employees posted to, according to the Bulgarian law, they have to start this shadow payroll, and the employee has to file a tax return until the end of April, just like in Poland, but over there, they have to pay the taxes in the euros. Czech Republic. the threshold for the 23% rate has been increased, and there's a so-called unified monthly employers report. This basically brings several reporting duties into a single report, and this is a new change coming into force in April this year. So let's come back to our Olena, who is now in the Czech Republic. So first of all, this unified report has to be filed starting from April. And the company that Olena is posted to has to file this new unified report. The employee has to file the annual tax return, and they have until the end of June to do that. Now, if Olena goes to Hungary, we have to bear in mind the digitization that's happening there. And this is a bit of a revolution. This is going to be starting next year, but everybody's preparing for it now. It's going to be a reporting platform which is event-based. So it's not based on periods, like a month, but the whole thing is about simplifying the reporting duties of the employers. In other words, certain events have to be reported rather than monthly periods. So the workload on companies is going to be significantly reduced. We'll see how this works in practice. Now it's being tested. But hopefully this event-based system will be less time-consuming and less costly for the employers. Now, when it comes to the obligations, let's say that is the Hungarian company that pays the wage. In this case, they have to keep the payroll on a monthly basis. But if the salary is paid from abroad and this person is posted to Hungary, then it is Olena herself who has to pay the tax. That's the principle in Hungary and in Poland, by the way. If we have a contract with a foreign company and we work in Poland, we have to do all the tax settlements on a quarterly basis until the 12th day of the month following the end of the period. In Hungary, it's until the end of May. I'm sure you know the Polish system very well. When it comes to inspections, certainly all forms of benefits, including benefits in kind for employees, are taken into account when inspections are happening. And tax offices believe that in these posting situations, this should be added if we pay any fees and extra costs related to their employment abroad, that has to be added to the wage we report. My practical experience working with a number of companies is that we always thought that the costs of legalizing someone's stay and their family's stay, we thought that was considered an extra revenue on the side of the employee. We also thought it was the employer's obligation to obtain the work permit, but in some cases this will be added to the employee's revenue, and it's taxable. And this is very important. If you read the latest interpretation from the Polish tax chamber or tax inspection, this is a revenue which is related to the work, so it should be considered an additional benefit that the employee is getting. And it may be a very important topic. If you have a large population of employees, then these could be significant amounts, and it might turn out that the personal income tax and the contributions you've been paying were not sufficient. Now, you definitely know that the National Labor Inspection Law has been changed. This was paused for a moment by the Prime Minister, and everybody thought this would just fade away, but it's back. And there's a brand new draft that has been sent to the Senate yesterday. It's an amending law to change the law on the labor inspection in terms of all sorts of civil law contracts, service contracts that are related to a regular employment contract. So, for example, if we've got students working for us, university students, pensioners, using the so-called contracts for commission, or if we have contractors working on a B2B basis, then the labor inspector will have the right to check whether the actual way the contract is performed in reality meets all the criteria. For example, is this an independent contractor in reality, or if there are certain hallmarks of this being an employment relationship. And the same goes for posted employees. So if we are sending someone abroad, or if someone is getting sent from abroad to us, it's the same, because it all depends on the type of contract you have with them. Now, there's the so-called return tax break, if you will, which was used when Polish citizens returned from having migrated abroad, but other foreigners can also use it, and this generates considerable savings. But obviously, it is audited quite a lot, and in our professional practice, we have seen a lot of cases when people were very strictly audited. Many people have used this break, and then they are asked to prove that they had the right to benefit from this break. So you've got to be well prepared for it. But you can be exempt from Polish taxation for up to 4 years, up to the amount of over 85,000 zlotys. All in all, that saves you over 100,000 zlotys over the span of 4 years. So that's a very considerable tax break. That's worth your attention, I'm sure. There are certain conditions that have to be met, but certainly this is something that should be helpful in bringing talent back to Poland from many countries. There are different conditions depending on whether you are Polish or not, whether you are coming from abroad or returning from abroad to Poland, but it's an interesting solution anyway. If we have a situation where there is a foreign employment contract and an employee is being posted to Poland, it is the employee who has to make sure to pay the monthly tax and then file the annual tax return and possibly pay the so-called solidarity contribution of extra 4% if they make more than 1 million. And there are some upcoming changes that are about the implementation of the new directives in Romania. Now, if we are posting an employee to Romania and there is a host company over there, then again, they do not have the obligation to keep the shadow payroll. And it's the person that has to meet the monthly requirements and obligations and the yearly tax return. Slovakia, with the new tax rates of 30 and 35%, you can see the brackets on the screen. and there's going to be a tax amnesty up until a certain time. You will not have to pay penalty for misdeclaring your taxes. And in this case, we need shadow payroll. If it was not kept, then this person has to do all the settlements, and then obviously they have to file the annual tax return using the appropriate rate. In some companies, employees have been posted for many years, and there's the so-called tax equalization at work. For example, it would be great for an employee to go to Romania or Bulgaria and pay 10% tax. But if you post them to Nordic countries, then the tax rates are higher. In Poland, they would be paying 12 or 32%. In Scandinavia, they have to pay more. So who is going to pay that extra tax? So companies often use tax equalization. Basically, what this means is that the employee the situation should be tax neutral for the employee. If they are supposed to pay more abroad, then the employer covers the difference. If the reverse is true, then the employer benefits from paying less. It's a matter of negotiating with the employees very often, and they might not be willing to go to a more expensive country. So this tax equalization is a procedure that makes it possible to make it tax neutral for the employees. Now, if we're providing services in country A, but there is a unit or a branch in the other country that we provide the services through, then what might happen is that even if we are registered for tax in Poland, and then the employee goes abroad and provides the service through their own work, then the other country might deem these services to be provided in a continuous way, and the so-called permanent establishment has been created. So we have to pay the corporate tax over there and the personal income tax. Thank you very much, and it's over to my colleague. Right. So we've been through all of CEE. I'd be very happy to talk about this for another hour, but I'll try to keep it short. When it comes to national insurance contributions or social contributions, this is something we've been talking about since yesterday, and we had a very interesting presentation today about this. And there are huge differences when it comes to social insurance contributions. There used to be dramatic differences, but now this has been harmonized by the EU. So the actual differences these days are very small. There are some small nuanced differences. It's more about what is being emphasized rather than any actual significant differences. Poland seems to be quite a liberal country compared to the other CEE countries. It's quite easy to get your A1. It's all been digitalized. You can do all of this online. The system exists online. All the applications can be filed online, so it's pretty straightforward, which is not always the case in every other country. Now, Poland has a pretty formalized approach to this. We look at documents a lot. If you look at the Czech Republic or Slovakia, just like in Western European countries, they often check whether this is an actual business which is running in this particular country, so that it's not just a letterbox company or a shell company where you have a location with a number of companies registered at the same address. But in those countries, they look at whether this particular company is actually doing business. When it comes to third countries, Poland also has this system. So let's say there's a person from a third country, they can stay in Poland legally, and we can issue the A1, and we have the 30-day limit, and they will get the A1. So we are liberal, because other countries sometimes say 30 days is not enough, and maybe they're trying to cheat us. So the approach is different. And we can talk about this a lot, but I would like to focus on a few practical aspects that have appeared in our professional practice.
Not only with reference to taxes, but also with a broader perspective. Now, remote work is a topic that we see in practice, but it is also quite surprising, especially for employers. Why? We all know what remote work means, but if we, being an employer, find out after some time that business agreed for remote work of an employee, and you suddenly have an employee who's worked from Portugal for half a year, then you might be surprised. Because, you know, if someone works from Portugal for half a year, then it is remote work. But perhaps then, as an employer, I would have to pay contributions in Portugal. Perhaps I would have to get registered there. So believe me, there are quite many such situations. So HR departments, payroll services, you know, they find out after some time only that their employees work remotely. So it's a dramatic situation and quite frequent, because there are policies in companies allowing their employees to work remotely from abroad. But these countries have this mechanism of having caps of 30 or 60 days. And where do these numbers come from? Well, we just think that, okay, if I allow my employee to work from Spain for 30 days, no one will realize. And well, generally this is the case, because it is not that Spaniards run to the beaches to ask people to show them their A1 forms. However, as employers, should you be obliged to provide social insurance in a foreign country if you don't have employees there? Well, yes. And I will tell you why. I'll give you a practical example here. So there are two situations here. So, for example, we have a company that has warehouses across Poland. And it is Christmas time. Suddenly you have shortage of manpower, and you employ Poles for 2 weeks, for extra 2 weeks. The warehouses are close to the borders. You know, they earned a lot. They were happy. And then in 6 months' time, you get a document from the Polish national insurer telling you that you should actually get registered in Germany, because you employed someone who lives actually in Germany, but came to Poland to earn some extra money. Yes, but this person didn't declare anything like this. Yes, they declared that they didn't have to pay contributions in Poland, but now it turns out that they reside in Germany, so they should pay contributions there. And then you have to get registered in Germany, pay contributions for the past time, And you don't even have this employee in your company anymore. You know, the person is gone. So this is all related to compliance. Another situation. We have an employee who leaves the company. So, you know, there's the 3 months to terminate the contract in the agreement, but we say, okay, we can terminate this employment relationship instantly. And then you find out that you have to pay contributions. Why? Because our employee, who still had this contract, went to Denmark to earn some extra there. And then the officer says that this remuneration for the termination period, that you actually have to pay contribution for that period. So I spoke about it in the context of remote work, but it concerns not only remote work. We've spoken here a lot about multi-state work. So because we have too little time, I'm not going to speak about it now. You just have to verify whether 25% of time duration, of job duration, takes place in your country, and then you have to decide whether Article 12 or 13 applies. And now, Polish companies that operate abroad, they really know what it means to let a person enter a construction site without the A1 form. But there's this general belief that if there's business trip, the AI form is not needed. But it is not true. Now, a social insurance system does not differentiate between posting and business trips. So if we're talking about social insurance and A1 forms, they are all the same here. And this also concerns PWD declaration. Now, the union says that they will harmonize it, that we will have this PWD declaration the same across all the countries. But now someone comes to Poland, files the declaration to the Polish inspectorate, labor inspectorate. And yesterday, Professor spoke about gray zone. So yes, this is also one of the cases of this gray zone. So business trips are not the type of stay in Poland where you have to make this declaration of posting workers to the Polish Labor Inspectorate. This business trip is a kind of category that does not exist in this area of posting. But it is a big issue because we don't know when we should make this PWD declaration and when not. Okay, let's have that you have an employee who comes from Czech Republic to Poland and they are to service a machine for 3 days. So should I present this notification of posting of a worker or not to the Polish Labor Inspectorate? So in such a case, should this notification of posting of a worker be filed or not? Because, well, this notification has some consequences, because then an employee who is in Poland is under the regulations of the Polish labor law, which means minimum wage and so on. And also information on the number of hours is necessary. Such an employee has to be trained when it comes to health and safety rules. So yes, you have to do it. You have to train such an employee before you let them enter your factory. Yes, but they're here just for 3 days. And then people decide, okay, perhaps they should not file this notification of posting of a worker. Perhaps the inspectorate won't come and they won't notice anything. Now, this is an issue that will stay unresolved. Now, when it comes to business trips themselves, let's remember that it's worth having a system. Even if we're not sure whether we should make notifications or not, it's good to make them. And if we have quite many of them, it is good if you have a system that will help you with it. Just to put it in a nutshell, there are also controls carried out by the Polish Labor Inspectorate. And, well, if you want to comply with the law, you file the notification. Yes, but if I file this notification, they will come and control me. If you don't do it, they might come and control you as well, right? Well, yes, but my experience is that once I file the notification, they come and do the inspection. Okay, I could speak about this PWD, or notification of posting of a worker, for quite a long time. Okay, let me now briefly speak about something that's important from the point of view of law compliance. Namely, making sure that you comply not only with labor law, but also with mobility costs. So you need to have the entire process ready. So whether this travel is short or not, you have to organize health and safety. You need to ask them about health checkup. Very often companies pay extra when there's relocation, reimbursement of costs, accommodation. These are things we're thinking through. There's also the issue of having a database, a central register, and monitoring of costs. That's another issue. What could such a process look like? A good process of employee mobility. Whether this mobility is carried out by HR or payroll department. So there must be the notification process. You have to have a system to verify whether you can post someone or not. Perhaps you need to have the shadow payroll. You also need to have this business decision and the right budget to make sure that posting of an employee will not generate extra costs or even losses. You need to have this package of documents, so some templates ready ahead of time. You have to be able to verify whether the employee has left the country or not, when they should return. And also, once they come back, make sure that it is all settled, because the fact that the employee has come back home in 1 year doesn't mean that everything is already settled. Perhaps you will have to pay some extra taxes. For example, in Hungary, you pay taxes till the end of May. So you must see some extra costs the following year. And now, when it comes to our Olena, what might have gone wrong here? So you need to check whether she needs a work permit, whether she can legally go from Czech Republic to Hungary, whether she can legally work from a different country than Poland, where she has this single permit. And again, if there's taxation due, if there's tax due in Hungary, because if you have a company there, perhaps this will mean that you have payroll in two countries. So these are issues that are worth bearing in mind. And the three last takeaways from this session. Now, you have to have this register of employee mobility. You have to have process where all these issues related to taxes, payroll, HR are covered, and you also have to remember about costs. So, okay, we have posted an employee, then we have to bear all the costs. Well, it's worth thinking whether you actually control all these costs, so that you also avoid some penalties, or you avoid business loss related to mobility of your employees. I believe that our time is up, so unfortunately we don't have any time for questions being asked here formally, but I'm sure you can ask them during the coffee break. Thank you very much.
Bardzo dziękuję.
Staraliśmy się nie przedłużyć za bardzo.
Nie, a ja starałem się bardzo pilnować, ale mam bardzo niewdzięczną rolę, przepraszam. Tak.
Rola, bo to każdy
Ja
chce.
bym w ogóle chciał tak rozmawiać. No musimy sobie następnym razem zrobić bez tłumaczenia żadnego. Wtedy jest ten reżim czasowy.
Może patrzeć się nie
Ten reżim czasowy.
widać.
Może ja sobie teraz zdjęcie wyślę.
Albo naszym po prostu. O. Tak, patrzymy.
in the sense that it used to be hopeless, plenty of infringements, only rogues and criminals. And what is it like now? Is it a bit better? And what time framework do we have for that improvement? I'll stay here. I'll be giving you microphones. All the following questions will be yours. I'll let myself start because I've been in this field for a bit more than Sebastian, and for that right, and by my birthright, I remember a bit more. I think it's a bit better, but just like I said yesterday, we've got different problems, a bit more complicated. The controls, even if it is better, are harder for us. We find them far more testing, and they are absolutely different irregularities that we encounter. And what we repeat, professionalization and specialization of the posting employers increases, it develops. What is definitely civilizing is the market of those true invisible services related to posting of foreigners to Poland. What it looks like today, well, that's my colleague, because for 8 months I haven't run a single control, and I miss those a lot. Now, please let me pass the mic to my colleague. I confirm I'm the inspector who knocks at your door if need be, but I promise I'm not doing it today. And certainly I can tell you today what it looks like, basically, if anything like that happens to you in future. In principle, our competences cover two things when it comes to posting for provision of services. Two courses. One, from the territory of the Republic of Poland, and also posting to the territory of the Republic of Poland. Basically speaking, both types of controls have their own scopes and they follow different principles. In the case of Polish entrepreneurs who post to different European countries, those controls decisively are based either on information for different bodies in the target states, in the welcoming states, and they really focus on two major aspects. The first concerns the actual entrepreneur, and here the main, absolutely the main aspect is whether they really provide services, whether they really function. So, being colloquial, it's whether it's not a letterbox company. That's how we call it in our slang. Here I have to admit that the recent years don't really uphold your theory that things are getting better and better. Better and better really depends on where we stick our nose into, where we look. Speaking about companies that have worked for years, when we look at Polish staff, companies that have worked for a long time, there have been no significant irregularities in this scope. However, what we see, what we've seen for quite a few years, that there are many new entities, and those new entities are also started by third country citizens who received various rights, who enjoy now those rights to do business here. And we observe this trend. Perhaps after last June, this trend slowed down and flattened, and it's not fully diagnosed yet, and it's hard to diagnose. Those companies are often devoted to virtual offices, or sometimes they are really letterbox companies, and all they have is a post box. There is no person. Employment comes from external companies that prepare documents, and foreigners are usually transferred from a third state to the country where they provide services. Services are provided according to spoken contracts, and there are no detailed documents. Now, the other aspect that is controlled concerns the staff. The main aspect is the legal bond between the two companies, between the employer posting from the territory of the Republic of Poland, and of course fulfilling all the duties of the employer. Information, then also our requirements for documentation. We as labor inspection, when we direct people to work abroad before they're posted, we don't control the conditions of the receiving state. And we never have received such a question whether the employer pays the remuneration binding in that state. They want to know whether they are employed here, whether they're insured, what period, when they were really posted, what the conditions of employment were. And that information really makes it possible to assess whether we really deal with the actual posting or is it only sham. In case of controls of staff to Poland, we work along the same principles. We check the same things, only, of course, the entities we control are foreign employers, other than so-called administrative duties that call for delivery of statements and also applying for all those people who provide services. They have duties to store in the territory of Poland documents such as copies of contracts signed with this foreigner or other document of similar power that confirms the conditions of employment in the host state. Documentation concerning the hours of work, starting time, ending time, and remuneration so that we can check those requirements that are defined in the posting directive and then implemented in the Polish Act. Speaking about that scope of control, I admit that the employers posting third country citizens, in the case of those who have their seats in the EU, there have been no major irregularities discovered. It would be hard even to find such a field. If there's something petty, it's petty. It's about the safety at work and health issues. But with employers who have their seats in third states, most controls find major infringements, especially when it comes to legality of employment. And it's not always directly caused by the fact that somebody, to be colloquial, just wants to have people working here in black. Very often such employers, they say they were waiting for a permit for a year, but they have a contract they have to cover and they were forced to send those people, to send them to work. Or they obtain a document that is a document for a different procedure, so A-type and not D-type permit. And then this entirety of the result of control decides what's illegal in employment. Not working in black, but illegal. There are also so-called campaign controls, and in those campaign controls, a group of inspectors arrive. They know that in a specific area there are foreigners working, and we simply stop them, and we check what company you're from, what lines you work along, and in these controls, if there is this information, let's say more detailed information, we also, well, it hardly ever happens to miss. There are very many situations which confirm both infringement of administrative standards. Somebody was not in any way notified. The question of stand-ins is very often caught. The people who are declared, somebody else comes in their stead, and these people are not declared. So there are plentiful infringements in this field, and it's not so that this generally improves. No. Let's say it otherwise. The change of legislation that was introduced last year also resulted in not all adjusting to specific requirements, especially when it comes to posting in the territory of the Republic of Poland. The procedures changed a bit. The procedure for obtaining permits, the requirements are a bit different. So these irregularities are somewhat there. And we have that privilege or the duty to deal with this. All I can say is that it's your business because they are your unfair competitions. I say it the way they from the inspectorate say it. Let's emphasize one thing with this following of the unfair competition. It's not fully so. We're trying, we're doing our best. That's the frog that I mentioned yesterday. And let's also remember that wherever those irregularities are most, where we find them, where we run the actual controls, this is posting to Poland. And most of you are those who post from Poland. I've got to refer to the words of my colleague so that you don't get the picture that it's those entrepreneurs who live beyond our eastern border who have free reign here. When we speak about the conscious breaking of the law, it is so, but again, I've got to spit into my civil officer's nest. Sebastian has only started to encounter that problem because in Opolski region, those big Korean companies arrived there. We in Lower Silesia have known that problem for many, many years. It is very often so that on the one hand is this conscious breaking of the law when it comes to entrusting employment to foreigners, but this results from the failures on the side of civil servants. Well, a foreigner posted to Poland to a tight company, for the first 30 days, they don't need the permit for posted workers, and they should receive it within those first 30 days. They never get them. And this is why they work illegally. The cost of bringing such a person from distant Korea are so high that it's easier to pay a fine than to either send them back to Korea. You don't know when this permit is going to be issued, or to keep them here and make the employer pay. Well, there's a bit of a problem here also for us as the civil servants, and that's the problem in our work. But I really say this is not my business, that's the regionals. Well, calculation of that payment is really short-lived because in the case of citizens of third states, when they work illegally, we have the duty to notify the border guards who will have those foreigners bound to leave Poland, and that will put an end to their activity. Yes, but the scale of our controls is so small compared to the number of people who are here. We've got limited resources and we don't get everywhere, but you haven't heard that. We'll go wherever we want to go. That's not what we wanted to hear. We wanted to hear that you're everywhere and we see everything. I've seen plenty of hands up. Okay, I have a question about hits or about snitching. As far as for a long time, when it comes to snitching for the employers, these were our locals, Poles. But when it comes to foreigners, we've got more and more notifications. But some have turned those notifications into a hobby. And now, what's the procedure with notifications with this, with informants in international services where premiums and taxes are counted differently? And it's often explained like, oh, it doesn't matter. It's the labor inspection or it's ZUS coming. And one procedure ends and the following one starts. As simple as that. Could I ask you about the procedure? How does it go if things keep on repeating? You get information from the same person. Or is it something like a fairy godmother information? No, we don't get snitching. No. All we get are complaints. Nobody snitches. Well, there are some formal requirements to submit one, and it's not so that everyone can write such a complaint and that we would respect every complaint. The formal requirements must be fulfilled, and basically, you really would have to do a lot to deliver an anonymous one and be sure that it is going to be looked into. It's got to have full name of the person who does it, and contact address has to be delivered. It doesn't mean that we're disclosing the data, because the fundamental principle is non-disclosure of the fact that we start from a complaint. We hold to that principle unless the person signing will say that they do want it. There are some who say, please inform the employer that the inspectorate has arrived because that person wanted so. There are objects of complaint that we can't get without disclosure that there's been a complaint. Very often these are issues related to legality of employment. There aren't many of those areas, but legality of employment and issues related to work hazards and to accidents at work call for this. If there is a complaint, it's anonymous, but it proves that we deal with direct threat to life or health, whether it's anonymous or not, we go to that control. What really hurts us, and what unfortunately happens more and more often, is that people lodging complaints, filing complaints, try to pretend they are other people. They use other identity, and suddenly you receive information about a control being carried because they lodged a complaint, and it turns out that that person never lodged such a complaint. Even worse, if the person who wrote something like that, sometimes it's vengeance or ill will, they point that that person wants the information that that was the person who wrote it is that person, and then we know what will the employer think about such an employee, especially in the case that the employer has no blame, is just beyond blame. So complaints are a major problem with us, but there are also those complaints that we can really do as office work and we don't go to any control. If such complaints come from the same person in the same area, unless it brings something new, some things have been defined previously. Controls are not repeated, but there are some employers, there are some businesses where we go on returning and returning, and those complaints are very frequent. Now, the bare amount of complaints is really mind-boggling. I don't know if you heard our boss speaking. He now publicly speaks that soon it can happen so that looking at the number of labor inspectors, we won't be able to do thematic controls.
And this will mean that we won't be able to inspect certain areas where an inspection is due, because we have to look into complaints, and there are so many of them. And we have to bear in mind that only a small percentage of the complaints is justified. I'm not sure if my colleague will agree with this, but in the past, people would complain that, for example, my salary wasn't paid. These days, it's not just a single sentence, it's 16 pages or 30 pages written by AI. And trying to get through all the demands of the claimant is difficult in itself. People use AI to support them, and sometimes they come up with such absurd legal basis that it's terrifying, and all of that makes us looking into these complaints much longer. So it's a complicated business. I can definitely confirm this. There's the latest data where we compare the previous year and the first few months of this year. We have seen a 40% increase of claims and complaints lodged with our inspectorates. So there are more of the complaints, and like my colleague has said, the scope is much wider. Many people add in their complaints a lot of other things that don't really pertain to the essence of the matter. And that makes the inspection longer. It extends the scope of the inspection. And basically, as a result, we have less time for other inspections. As a result, we can't inspect things more frequently. For example, if there are further complaints about the same employer that has already been inspected in the past on different grounds, we very rarely come back to the same employer because we don't have enough capacity. Sometimes, if there is a new thematic element that has not been inspected before, then we can come back, but normally we don't. So to begin with, we would have to look into what sort of complaint this is. There are the so-called direct employees complaints. There are third-person complaints, where someone tells us who they are, but they talk about something that doesn't pertain to them directly. And there are anonymous complaints as well. So depending on the type of the complaint, the type and scope of the inspection will vary. If a complaint shows that there is danger to someone's well-being or health or life, then obviously that's a priority. There was a question of the nationality of the people who file complaints, and I think we can very clearly see the cultural differences among the claimants. And this is to do with the nationality, and this is also to do with different generations. The complaints of older, more experienced employees are quite different from Generation Z, for example. The content of the complaints is completely different. But when it comes to foreigners, I had a situation myself where an employee from a country to the east of us was not paid. They filed a complaint in Wrocław. 5 days after the complaint, this person came to our office and said, what's going on with my complaint? Why haven't I been paid if I complained about it 5 days ago? And he was quite aggressive in his dealings with the janitor in the building. And then he came to my room, my office in the building, and said, he sat down. He said, now you will have to pay my salary, and if you pay it from your own money, then you'll be faster in dealing with the employer. So this is the sort of different approach. The demand level is quite different. These people don't seem to understand that they are not the only person whose case we are looking into. They also don't understand we are not the police and there are certain things we cannot do. You know, we can't just call the employer and they will immediately make the bank transfer. So it is getting harder. Thank you very much. I will have a question, but let's start with questions from the floor. Thank you. My question is about the temporary employment agency. I have this problem that I've had forever in our financial settlements. We post employees to a country where the weekly settlement period is completely different than in Poland. If the employee works 3 days times 10 hours in Poland, then the 8th hour is paid normally, but the 9th and the 10th hour counts as overtime. Now, in the country that receives our employees, they say, hang on a minute, they will only be getting overtime if they have worked 35 hours in that week. The fact that they work for 10 hours during a single day doesn't matter because they have not exceeded 35 hours in the week. So the question is, what do we do to make sure we're on the good side of the law in both countries? There are a number of rules here. First of all, a temporary employee should have the same conditions as that employee over there. But that company says, I'm not going to pay that because my employees would not be getting overtime for that. The directive says that we should be using the better of the two sets of conditions, and in this case, the Polish conditions are better. So which do I use? If you follow the directive, and if you follow on temporary employment, because I understand this is about temporary employment, isn't it? So first of all, yes, it should be in line with the provisions of the law in the host country. If we are to look into which sets of rules should be more binding, in this case, this is not for the labor inspection to say. If a claim is made to that effect, the employee can go to court, both in the host country and in the country of origin. But, like I said before, I believe that the users regulations, users country regulations should be treated as primary. Yes, and the labor inspection does have the competence to rule on this. This is within the sphere of competence of the court. Overtime rules are indeed complicated when it comes to posting, but there is this main underlying principle for temporary work. Thank you. If I ask the inspectorate for an interpretation, would that make sense? To be honest, I've also come across a different opinion than what you've just said. This is something we said yesterday, I think. We are not allowed to issue official interpretations. So, you see, even if an inspector, for one reason or another, believes that the principle of better benefits should be used, they can't rule on that. The labor inspection is an organ that can provide interpretations when it comes to people from abroad being posted to Poland, not the other way around. If there is if we have two legal systems in essence, then, as the directive says, it is not our task to rule on that. So a query like this would probably be better addressed to the Ministry of Labour. I have a better idea. Maybe a good addressee for that query would be the labor inspection in the host country, the country that you post people to, as long as they have the same powers as the Polish labor inspection, as long as they can provide interpretation on that. Yes, every country has to have a counterpart body that, among other things, provides information, but this is just about people being posted to their own country, so they can't rule on what is more beneficial to the employee. So I'm not going to get an interpretation that takes into account both legal systems at the same time. Right. I will be very happy to take this question. The directive says that you are allowed to use the conditions that are more favorable. So the employer has the right to use the more favorable conditions, but they don't have the obligation to use the more favorable conditions. This is what the principle of favorability is all about. So the intent of the EU legislator is to make sure that the employee doesn't lose out when they are posted, but they don't lose out here. It's about protecting the interest of the employee, but like I said, the principle of favorability is not obligatory. If a posted employee, and in this case they are posted from Poland, and it seems that our regulations are more favorable, if they receive overtime payment, that would probably trigger discrimination rules in the host country, because this person would be treated better than the other employees who are over there, who are not posted. If we received a question or a complaint from an employee like this, we would refer them to court. We would want the court to confirm that the right to overtime exists or doesn't exist. And the court would also then inquire other information in another court in the host country. We have experience when it comes to testing court's opinions. If you can't get an individual opinion from the court, then we find an employee who's not very negative against the company, and they agree to file a complaint against the company in order to test what the court will rule when it comes to these two conflicting sets of regulations. Now, it's not a very costly solution. It's effective. Yes, it puts more burden on the judiciary, but it's a tool. I hope I'm not, disclosing a secret here, but this is what you can do. I would like to come back to the issue of posting foreign workers to Poland. We have the posting declaration, and we have talked about it before. And we have also been inspected by the inspectorate. My question is more about business trips than actual posting. We have a servicing agreement. There's a foreign company that has this agreement with a Polish company, and they send a group of service people for maintenance and servicing of machines to Poland for 5 days, for example. So my first question is, do we file the notification of posting a worker, or what we call the PWD? I think I know the answer, but I want to make sure I'm clear on this. And secondly, if this notification is filed, there is the obligation to keep the documentation in Poland. So the host company will normally keep the documentation. My question is, what is your approach in your inspectorate? Because it seems that every province of Poland has a different approach when it comes to inspection. We have the same guidelines, so we shouldn't have a different approach and different interpretation in different provinces. Could you disclose these rules and guidelines? Whenever we inspect anything, we have the rules of inspection. My colleague here is the coordinator of something like that, and he makes sure that these principles and rules or guidelines are uniform across the country, although it might happen that something might be slightly different elsewhere. Now, you are asking about two contradicting elements. First of all, you mentioned it was a business trip, but then you said that they come to Poland to provide a servicing. Yes, but I don't think that this is contradictory. If they are sent to Poland as a result of a service being provided, then they are under the regulations concerning posting employees for the provision of services. And then it doesn't matter how long they are posted for. The employer has to file a declaration with the labor inspection no later than on the day of when those services are started in Poland. And this should be constant wherever you are in Poland, because you file it with the chief labor inspectorate, not with the provincial labor inspectorate. So these local inspectors aren't even competent for that. So it's always the same. You have to file it with the central office. I think it's probably about how we understand the word posting and business trip. Our law doesn't include anything like business trip. Yes, we have talked about it before, actually. We've talked with Marek about it. This is a suggestion that we've had for years. Ever since I've been at the inspectorate, I've been talking about it. We need a clear and transparent definition of what posting is and what a business trip is, and how they are different. The type of how this foreign employer sends their employees to Poland in the context of the directive, which has been implemented through national legislation, it shouldn't matter that much. It's the type of service that makes this fall under the directive or not. If this is done as a business trip, then this would be inspected during the inspection of the conditions of employment. Also, the question is, are they posted from a country that has its own definition of a business trip? When we reply to the IMI applications, and when we talk to other EU countries, when we talk about business trip, very often we hear the question, what is a business trip? There are these things, like the business trip, which is defined in Poland, but it's very often unknown in other EU countries. If we have a posted worker and there is no definition of a business trip in country X, but suddenly this person thinks that they are on a business trip, I think I fully agree and with what the inspector has said.
That assessment is not the content of what they do, but it's content, not the name. Is it business travel or posting? But inspectors generally say that something like that exists, but that's not a binding legislation, even when we speak of foreigners arriving here for a very short time. Now, the other question relevant to that is this obligation to document it. Somebody arrives here for 5 days. Yes, we've already agreed. It seemed obvious, and you are confirmed. Now we have our duties to document, evidencing the time of work, pay slips, and all that. I've got 30 people arriving here for 5 days. My question is, this whole documentation, does it have to be now in the territory of Poland? I'm not going to say that. It should be so in theory, but should it now be available to the state labor inspection? Should the foreign employer provide it? They can't really record their time of work if they work at my contractor. I have no way of entering that. They've got some kind of badge, pass. I can't have access to it as the employer. The question is about the documentation duties. What should that foreign employer present to satisfy your needs? I know the list, but the question is about the practice. How does this theory translate into praxis? The list is contingent upon the directive. These duties are the same in every country, but the fact that it's 5 days is one thing. Remember that the labor inspector has the right of investigating this 5-day period up to 2 years after the period ended. And it's really so that we very often get to businesses and we reach places where there are no more any posted workers anymore. That's why we need those documents. They are absolutely necessary for us now, justifying the lack of, for example, recording of the hours of work with technical obstacles. No, not really. So let me start from the beginning, because the employer posting people to the territory of Poland by making a statement about posting, they choose both the place where these documents are to be stored and names the person who will either be represented, be entitled to represent, or will be an intermediary in the contacts. It depends whether this is somebody in the territory of a member state or a third state. That documentation, evidence, and contracts can also be stored in electronic version, so there's no duty to have any documents that have been printed out from something. But speaking about that evidence, there's this broad approach These must be documents that state the starting time and ending time of work on specific days, and the employer that has at their disposal both the option to define and they decide when the staff work. I can't see any obstacle for which they should have no knowledge about the hours when somebody worked. If there is such an obstacle, I'd like to know what obstacle that was. If they don't want to say when they worked, or what is it? You do it in real time. It's not that you do it 2 years later when you check things like posting. No, it doesn't work like that. And well, I've had it that a child threw away some documents, laptop broke, and files couldn't be achieved. Well, I use services of a Ukrainian company, and now I no longer work with them. I don't know whether that company is still there. It's not you who should have it. It's the employer who does the posting. Okay. But you, as inspectors, come to control the companies that post to Poland. There's a Ukrainian company posting to Poland. They've got somebody here who supervises that stuff, and suddenly a question arises that the company stops working. It no longer exists. It's not Schengen, it's not EU, it's not even the EEA. What actions can the inspectorate do? Will you address the Ukrainian inspectorate? Control over the Ukrainian employer, but if we don't have the employer, we don't have anyone to control. You come to control. You say that there are illegal employments and all. No, we control the foreign employer, but that employer is gone. Once again, on the 28th of January, you come to whom? To the employer who posts them. So we have the foreign employer, and they learn from the Polish representative. There's labor inspection, and we can pay 200,000 zloty penalty. Wait. And then suddenly that company learns that something like that may happen and can be liquidated in 5 days. Notary Public does it in 5 days in Ukraine. What will the inspectorate do then? The control has already been initiated and the company suddenly closed. It's EA, it's not Schengen. If there's continuation of activity, it all depends on the irregularities discovered, because the lack of continuation of controls is not an obstacle in other procedures, administrative, tort. Well, depending on what has been discovered earlier, the company may not exist, but there are people. But you're talking about a representative, yes? A representative of a Ukrainian company, so they are entitled to represent that company and they're responsible for their operation. And now that the entity ceased to exist, that's a bit of a trap. That's a bit of a trap in case of entrepreneurs acting in other countries than Poland when we have penalties through administrative decisions. We have a procedure against a person, not against a company. So we will now be persecuting that representative for irregularities, not the companies. So the control may be over. It's over with the moment when there is nobody to be controlled. But in no way does it harm the options of continuing or undertaking other procedures, information, activity, notifications. It all depends really on what was discovered on the actual irregularities. In the case of people who could be harmed, we as labor inspection cannot provide any legal issues because there is no body, but those people have the right to sue, to litigate. Well, in my history, I've had a similar situation. It's happened to me so that I disclosed, let's say, dubious in the process of posting. You appeal one notifications, and it turned out that they were really forged. They were never issued. And as much as we, labor inspection, couldn't do much, the ZUS, by cooperating with the Ukrainian Retirement Institute, had the people responsible punished, and also the Ukrainian prosecution did it. So escape won't always terminate the activity, the control activity. Well, we can't do anything. No, we can do things. Nobody takes those actions to our request, but things like those happen. We very thankful to ZUS, which in this scope has greater competences. Same to all the tax administration, tax offices. They have their entitlements, their rights, and you can combine those with the irregularities related to ZUS and to tax. And these procedures are conducted on quite a broad scale, and people who in some way infringed the law are punished. Let me only add that foreigners cannot feel impugnable, because if information is passed to border guard, in case of control at the border, they learn that people infringed law. The border guard may use appropriate sanctions and start control. Thank you very much, ladies and gentlemen. As things usually happen at workshops and at our entire Congress, when things get interesting, one needs to end. Thank you very much. Thank you very much. Thank you, Sebastian. Thank you, Agata. A big round of applause for you. And the wrap-up is very short. The organizer this year is the European Labour Mobility Institute, the honorary patron, Ministry of Development and Technology. The Congress was co-financed from the funds of EU as part of Mobile Care. And one of the workshops was devoted to the wrap-up of the project. The main project of the Congress is Camden. Thank you very much, Marta, for support of the Congress and powerful content contribution. Content partners are the Coalition of Polish Service Exporters, Polish Hauska Association, and Rialto Partners. Thank you very much for support. We make sure that always this support is strongly content related, and it is so this year with the group of our sponsors who have been DBA from Paris. I don't know if we have Agnieszka Waszkowski with us. Thank you very much. Raczkowski office, law office from Warsaw. I emphasize Paris, Warsaw. Don't know if we still have Michał with us. If so, thank you very much. Giulio Cesare, law office, an epic name, by the way. Daria's gone, that we know. And Vieni and Tate Cube team who are here with us. Thank you very much. A big round of applause, please. Let's put our hands together for all of them. This year's Congress was first of all marked by the new barriers. That was a certain dissonance or perhaps some kind of clash between what the European Commission declares, especially you, Ursula von der Leyen, and what you experience in your everyday reality, in your everyday work. On the one hand, we have a very clear signal, and I believe it is honest about lowering the barriers. We see the first steps that the European Commission took, first to identify and then to take down those barriers. That follows the slogan of simplification of legislation. Simplification does not always denote deregulation. As Mr. Bartosz yesterday emphasized, we both repeated it yesterday, regulations are good, but only when they are good. Unfortunately, this Congress followed the motto, or maybe not alas, but it just followed the motto of catching the bad regulations. There are two groups of those. One are those that evidently break the freedom of provision of services. They break the treaty. This has started, and I'll proudly say thanks to the effort of European Labour Mobility Institute, especially Stefan and Marcin, who took that issue of illegal Wandererst visa followed. They first took up this issue, then they notified the European Commission, and after 3 years, the European Commission recognized that this argumentation is so strong that the infringement procedure should be started. Now we've got to fight against a barrier which is absolutely nonsensical, beyond understanding. The question that is asked most often about the blocking of issuance of visas and permits, well, if the body learns that a third party infringes the law, the blocking of those visas and work permits is so evident that usually they say somewhere there behind the curtains why they did it. Answers to this question are beyond our understanding. We were also looking for the source of that barrier, and we found those sources, and those sources are not positive. These are not the sources that would be easy to combat, because they lie very deep in mentality of some Polish officials. Speaking about officials, today I had a very short elevator speech with Paulina, who asked me, we were taking our elevators, which is lifts, to different floors, which surprised me. And I really know, because I work with civil servants also in my academic work, that Polish officers have changed in the last 15 years. Especially those that we had the opportunity of hosting on our stage, ZUS and State Labor Inspection, they make sure, they really do, so as not only to make an impression that they are entrepreneur friendly, but to be entrepreneur friendly. And we have several examples of those regulations which make nobody enjoy, labor inspection included. You know, yesterday the parliament passed the act on a novella of state labor inspection. And now this labor inspector who has just built here quite a warm image. Although he was trying to scare you that he'll be knocking at the door, but now they've got a BFG gun. Well, they don't have that instrument yet, but they have the BFG gun. You still go through the Senate and the president signing. I'm so happy that you didn't take that elephant in the room to the stage. We were still speaking about posting workers, but what surprised me most is that there is such a strongly pro-business attitude of civil servants.
Tę zmianę również Europejskiemu Instytutowi Mobilności.
And this is also something to do with the European Labour Mobility Institute and the Labour Mobility Initiative. The ice-breaking stage was 13 or 14 years ago during the first Congress, and the idea behind it was precisely to bring the national insurance, the ZUS employees, with other stakeholders at a university in Krakow. The idea was for the sessions to be short and for the breaks to be long, to make sure these people can come together and they can talk to each other and finally understand certain differences about how they will interpret certain terms. 13 years on, Professor Veskurin was actually involved in the creation of the law, but there are other professors who discussed it. And this case remains unsolved after over a dozen years. What has changed is that when we're outside during the breaks, people tend to cluster together much more and they are closer to each other. During the first conference, the people from the ZUS, the Polish National Insurance Institution, were in the one corner of the room and everybody else was in the other, and they didn't want to talk to each other. Now they do talk to each other and now they are closer to one another, and I'm very happy about it. The next Labour Mobility Congress will hopefully happen in early March 2027. And that will be quite special. It's going to be an anniversary Congress. But it also depends on you, ladies and gentlemen, how special it will be. The one that is drawing to a close right now has also been special. First of all, I would like to thank all the speakers. It wasn't easy. It wasn't quite stress-free. I'm looking at Ada, she's over there to the right. So, but everybody was extremely competent and they presented the experiences in a very positive way, and they were so willing to share their knowledge. I would like to thank the authors of the workshops today. This is certainly an added value for the format we have adopted. I do hope I'll see you again next year. We will have another round of workshops as well. Now, what I've been hearing from you during the breaks in terms of suggestions was that you would like for us to be able to meet more often. Now, I, for one, am always a supporter of real live meetings. If I see you in 3D, in person, it's much easier to talk to each other, but we will certainly be organizing online webinars as a sort of a follow-up after the Congress and maybe as a sort of a warm-up before the next Congress. So we will not let you down when it comes to this. And I've heard from a number of very eminent experts who have already agreed to host those webinars. So keep following us online to make sure you don't miss out. And finally, I would like to thank everyone who decided to save the date and spend this time with us by coming in person. This is a true community that has now emerged after more than a decade around this Congress. Now, I've been learning a lot from all of you, and this is something I value very much. And I would like to thank everyone who did very hard work to make sure this Congress happens. Ania Grodecka, Lidia Szczewska, who should be here. Oh, thank you. Thank you so much. Stefan, Marcin, who supported the agenda from the content-related side. I would like to thank the volunteers, and they should be somewhere around here. I would like to thank the interpreters. Thank you. Our thanks go to Pavel's team as well, who have provided the lighting, the sound system, and so on. I would like to thank the camera operators, especially the person who's been doing the short films that we need for social media these days. It's a new format that we haven't had before. So I do hope to see you sooner than in 1 year. Have a very safe trip home. And hopefully you will have a lot of interesting conclusions after this Congress. Once again, thanks, everybody. And this is the end of the Congress. Thank you.